Yes, we have the status.
Sorry, my bad, I do not have the record. I'm without contact. Second file.
Okay.
If I may just please, my lord.
Contextual computer technician instructor.
My lord, yes. Whether that scheme, my lord, is still. Whether this RGCLP scheme that I have been. Another time,
Get the
Rajiv
information-
Gandhi Computer Literacy Program, my lord, that
By 2 o'clock, get the information telephonically. Matter might have become infectious.
infectious.
There is another reason for that. On 22/2019, there was a statement made by Mr. UK Nair that the engagement of Dulumani Boishu, that the private respondent, has been terminated. And therefore, the petitioner who was at serial number 2
Two should have been.
was entitled to be engaged. That is the last position.
That I do not know how far it will stand, because once the appointment is offered on a select list, the select list expires as per the Supreme Court.
No, you are absolutely right. That's why I'm asking you, just get the information. I think this matter is otherwise in progress. Try to get it by 2 o'clock.
I'll
You keep that second file with you. In any cases, you require that the second file, please tell the court master.
my lord, yes. Actually, we are trying to revamp the whole our record systems. So many disposed files were taken out, and now we do have quite a few files.
So whatever is required, you take it.
I'll do. Oblige me.
Please, my lord, can you please pass over the matter for time.
Ending. Just a moment.
Kuntu? Kita mau itu tuh minggu depan. Baru udah ada belum?
This is again the same thing, 2011.
It has to go back.
Just take it after some time.
Under,
In the meantime, you go through it.
So in item number 6, I was required to take some instruction based on the 2 affidavits filed by the petitioners. I did not have a copy of it on the last occasion. Perhaps WPC number 3224 of 2020, decided on 25/11/2020, will cover the issue. It was exactly the same situation, the same grade 4 post. Schools were merged, schools were amalgamated, and whether they can be considered for the second post in the amalgamated school. That would be my WPC number 3224 of 2020.
3224 of 2020. The petitioner's name?
24. Sunil Rajbanshi versus State of Assam.
What does it say?
My lord, Sunil Rajbanshi is it was my case, my lord.
Okay.
And that case is different and that case is
No.
different.
I'm saying it is the same because the schools were amalgamated. Grade 4
In
post.
this case, I want only to send my matter to the high power committee because this case is under the Act of 1972 and that case was under the Act of 2011 and 12. My case, that case.
Either case.
Sunil Rajbanshi, my
This,
lord. So it is not
Sunil
covered
Rajbanshi-
with this case.
Sunil Rajbanshi also said that it has to go back for
Yes,
reconsideration
that is
because
correct.
now there is a vacancy.
Yes.
schools have amalgamated and one cannot ignore the fact that there is a vacancy and he was serving in the post. So that had to be
So my
reconsidered.
lord, your lordship will not accepted that order because I'm sorry, my lord, I shouldn't say like that. It is not covered, my lord, because that is case under section 2011 and 12 Act, and that act was not available now.
This is
So
very-
he should go for
You
2007.
must understand what is the nature of submission being made. We are opposing just for the sake of opposing.
Yes.
He is also saying that it should be sent back. But you are
Sent back
opposing.
where, my lord? It is sent back to the director. But in this case, my lord, high power committee is still existing. And
Is there-
second post, my lord,
Our instructions are that it only assembles when there is a court order. Otherwise, that hyper committee is not functioning on
It's
a
not there.
regular basis.
Who are the members of the high power committee?
because I'm under the act of 1977.
There was a nominee of the secretary.
And
There
this
was
case
the
is
director.
director and secretary.
The concerned districts inspector and the DO.
Nice, inspector nine, director, then the commissioner and secretary. How is it? Under secretary maybe ten. It will be responsible to move it. I have annexed one copy of the
Where is the impugn order?
impugn order, my lord, annexer K, page 55. What you got it? The matter of the Mosinali of Janata High School, Burinagar, Nalbari was placed before the committee as per government memo dated 29/2/96, and there 29 there was a provision only for one grade 4 post in high school and one sanctioned post grade 4 was allotted to at the time of provincialization, and I was left out, my lord, and all left out grade 4 approached this honorable court. Then honorable court passed an order to make a committee and place all the petitioners, all the cases before the committee, and they considered the case. I have,
But your
my
case
lord,
was considered and dismissed.
yes, dismissed, but it is wrong, my lord, because I was at the second gate 4. And all the second gate 4 approached this honorable court. That is why I approached, my lord, that too.
No, you
Joint secretary-
you show me the legal entitlement under the amalgamation scheme.
And my lord, I have annexed one covered case, my lord. This honorable court has already been passed an order, my lord. That is on, my lord, the similarly situated person was already been regularized. I have submitted on that day, my lord. That is 19/11/2019 in WBC number 2801/2017. Now,
Give me a
respondent
copy,
should
it's not
say
there. You give me
Wait.
a copy, it's not there.
copy is there.
No,
That
it's
day I submitted. Oh, I have only one copy. Anyway, my lord. Which one, my lord?
it's not there.
I did just my check. Number two, লিখি নাও। 2801/17. I only that
No, from the scheme, you show me that you are entitled to be considered. Where is the scheme of the amalgamation? From that scheme, you must show that.
no, I am
You are
not
entitled.
going for amalgamation, my lord. I am going for regularization of the petitioner's service my lord, as a gate 4. That amalgamation part is not comes in this case because I was in the petitioner was working before 1991-92, where the school was provincialized 96, my lord, and they were left out. And all left out persons came before this honorable court, and honorable court passed an order to hear the matter by way of appearing before the high power committee, my lord. And high power committee rejected because I am a second gate 4, and all the second gate 4 were regularized, my lord. Why my other senior
You
counsel
see,
not
maybe by
submitting
saying
like-
that you won't get that post because you'll have to show that there is a civil post and it is there in the school. Unless there is a post
No,
created.
I may not be, my lord, I may not be regularized in the same case, same school, my lord. I may be regularized in other
That
school.
can't be done. That can't be done. After, you see, regularization by after post Uma Devi is not permissible. That's
Now
why
the
I'm saying, you
question
see-
is whether second gate four, the persons of the second gate four
see, Supreme Court has
services were
category-
regularized or not.
Supreme Court has categorically stated that the High Court cannot regularize service. There must be a post and you'll have to show that you are entitled to be adjust.
That is why, my lord, my prayer is that your lordship kindly place the matter, pass an order to place the matter before High
No,
Power
that won't
Committee.
help unless I,
They will consider everything.
Mrs. Devi, that doesn't help. Because of the fact I must give a finding that you have a right. You see, every case a representation can't be sent to the government. The order must be implementable. I must adjudicate and find out that you have a right.
My lord, I have come on basis of High Court's order, my lord, in this case.
But that contempt, after the contempt was, after the contempt, when it was rejected. Then now you have to show, you have to demonstrate your right.
Then,
I-
my lord, your lordship, since he submitted Sunil Rajvanshi, your lordship kindly pass an
No, no,
order. on
even,
this.
even, you see,
Give
no.
me some time then, my lord, so that I
You have to
can
demonstrate,
place.
you see, please try to understand.
Yes.
Post Uma Devi, I have to give a finding.
No,
that
Uma
you-
Devi
you
is
are
the
entitled to a
irregular
right.
post, my lord. Uma Devi's place, post is all irregular. We are not irregular. We are working before the provincialization of the school. At the time of provincialization,
No,
we
you
left out,
don't-
but our service were approved by the government before the provincialization of the school.
Where is that?
Yes, my lord.
Where is that?
That, that
what
is
I'm-
page
I'm-
22,
I'm just what I'm telling you that you like.
Annex D.
That the second post was approved by the government. Page
Yes,
22.
my lord. Annex D, page 22. Mushin Ali, the last one, 13. And Annex
This Devi doesn't-
21, lordship,
this
Annex
is-
21.
This, it doesn't help you. You see, page
No,
22,
No, no, no.
look at the last three lines.
No, my lord, page 21, I'm sorry.
Portal is
Action taken by the managing committee, Janata High School, Borigok. Their regulation against the appointment of teaching and non-teaching staff of the same is hereby provisionally approved against the designation in mentioned below. My name is 13, Moshin Ali, gate 4. The approval of appointments at periodic temporary. After that, I was left out because there is only one sanction post at the time of provincialization. Thank you, sir.
Yeah, আপনি দিয়ে ওখানে স্যার
Kuntu, I hear you.
আপনি
Sunil
দিয়ে
Rajvanshi.
বকর আবু বকর
Got to hit to heavy. It is correct. And if it is second gate 4 is provincialized, similarly situated person, then I should also be provincialized, my lord.
No, no, you see, example is very simple. I have a secretary with me. Correct. Now, there may be a post which is there existing, but
Hmm.
doesn't have a secretary. So you can't say just because X has a secretary, now you please provide me also with a secretary. Same thing here, you'll have to demonstrate that you have a right. That second post exists in that school.
I have a right on basis of court's order, my lord. Because courts have already been passed an order
Court
to
can't create a
regularize
post.
the
Court
service
cannot
of
create a
the.
post, it will be unimplementable order. I can't create a post. I
No,
can
no, no,
only,
your lordship, this honorable court passed an order to regularize the service of the petitioner. For that, they have sent all
No,
the,
that's what I'm asking time and again. Can there be a regularization without a post?
no, that will decided by the High Power Committee, my lord.
It can't be decided by them. They can't create a post. Post can't be created without the concurrence of the finance. That's why I'm asking time and again. You show me the right.
I need some more time.
Okay.
Fix this matter another day.
I will return you back your order. On the court query, both sides are represented. On the court query as to whether the post of second grade for employee to which the petitioner claims regularization is a post that exists in the concerned school or not. or even Ms. K. Devil and counsel of the petitioner, case for notifying the district court. This one. This goes after you.
We are lost. Highly obliged. May I check back the order?
Yes, I will giving you back. 25 for.
25 4.
7. Return back is.
Student for minority. Yes.
May please your worship. Yes. Mr.
In
Raj.
this matter, the petitioner took admission for M.Com under distance education mode, the Guwahati University. Now he cleared, in the previous, he cleared 4 papers, my lord. In the final, he cleared all the papers. So as per the prospectus, now he should complete the courses, he can complete the courses within a period of 4 years.
Yes, Mr. Fukan.
My lord, we have filed an affidavit on 3/3/2023.
Yes,
My lord, paragraph 4, my lord. They will have maximum 3 chances within 3 years.
okay.
So, my lord,
This is 2016, so otherwise also chance is gone.
my lord, that 3rd chance is already over. Now they are for 4th chance. It is not permissible, my lord. Paragraph 4, my lord.
Affidavit in opposition for 1, 2, 3, and 4. 1 to 5.
1 to 5, my lord, all the respondents. Paragraph 4, my lord, may I read, my lord?
Paragraph 4 only says the statement made in paragraph so and so are matters of record.
My lord,
Lordship can just have a look at
Additional
the
affidavit,
last
my lord.
order passed by this court, then a picture will come, my lord. Here.
Okay.
Last order.
The
That's the
11
6th of February.
11 January 2017.
The 6th
my
of
lord,
February.
6/2/2023. Order dated 6
4/23.
February 23.
Last order of this court.
6th February.
6
of
February
23.
23. my lord.
That is relevant.
We have been directed to file an additional affidavit, my lord.
But Mr. Nath,
Mine.
from your own documents, I don't find that he'll be entitled to.
Please come to page 37.
37.
37, yes, that's the clause. That is the relevant clause. Clause number 13. That is the prospectus. Clause 13.
Yes.
A candidate for MA, MSc, MCom, MCJ, such and such degree must pass clear all the courses, papers prescribed for a particular subject within a period of maximum 4 academic year from the date of his enrollment in order to get the said degree. My enrollment was on 26/9/12, specifically said 4 years. Now I completed previous 5 up to 5 subjects, I cleared 4 subjects. Final, I clear all the subjects. But when subject remained, my lord, to be to clearance, then I submitted I went to submit that application, my lord, and the fees in 2016.
This is, you went on which date?
My lord, kindly see my that application. Page number, my lord, 76. Before that, my lord, kindly see page number 74. A notice issued by the university. MCom such and such semester previous to be held on
You are-
August
You are a
16.
student of which year?
MCom,
MCom
12,
which
13
year?
stream, 12, 13 stream.
12, 13.
Yes, stream, yes. August 16. Now that date has been extended by the next annexure. Fixed on 15th June 16. Fill up the examination form. Page 75, it was
No,
extended
just-
30th of June,
Just a moment.
my lord.
The repeat back examinations of so and so.
Page 75, 30th June, they have extended. The next page, my application. Page 76. Bottom left side, date is 7/6/16. With this document, I went to submit this one along with my fees. But they have not.
You cleared your first year and second year?
First year, out of five papers, I cleared 4 papers. Paper number 2, I could not clear. And final, I cleared all the exams.
That is in which, where is that mark sheet?
That mark sheet, my lord, that mark sheet is. Here, my lord, mark sheet is
Page
page
70.
number 70.
Okay.
Page 70. Page 70. Paper 2, my lord. 17 marks. Other things I got through. In the right side is written passed in paper 1, 3, 4, and 5. It's only one paper. And page number 72 is the final exams mark sheet, my lord. The list of successful candidates list, page 72, relevant part is page 73. In the second column, my lord, is page 73.
Mr. Fukan,
My lord.
then reading page 37, clause 13, and this notice at page 75.
My lord.
For second semester previous, he had the chance to appear in 2016. This is 4 academic years, not 2.
My lord, kindly turn to page 40, my lord.
40.
My learned friend shows page 37,
Yes.
now page 40. Same annexure, my lord. Clause 7.3. The first 4 lines. Page 40 of the writ petition. Candidates fees to be paid for second, third chance back paper candidates, not fourth chance, my lord. Candidates reappearing in the previous final examination of the MA, MSc, MCom. Here it is MCom, my lord. MCJ program for second, third chance back papers are required to pay examination fee of ₹1,000 for full papers or more than 2 papers and ₹500 for appearing in maximum 2 papers.
No, correct. That would
Now-
be, you see, third chance means the first chance is already there. That is the original chance. You don't count that.
My
Third
lord,
chance means, no, it is called second chance or first chance.
my lord.
So
Now,
how
my
will-
lord, it will be, my lord, read with the MCom regulation, my lord. So, my lord, my additional affidavit in view of this honorable court's order dated 6 February 2023, I have filed a additional affidavit on 3 March 23. My lord, page
No,
number
no,
91.
Just a moment, let me understand this first, page 36. Page 36 says. The program is divided into 2/4 modules,
My lord,
that is previous and final. Correct.
my lord.
Now, the semesters are,
We are
It
not
is
under
in the
semester.
yearly mode, not semester mode, my lord. My lord, the read petitioner is in the yearly mode,
yearly mode.
previous and final. Now the semester system has been introduced later, my lord.
No, but this regulation applies on him, to him, or it doesn't apply to him?
My lord, this page 35, 36 applicable to him. But it will have to read together with the MCOM regulation of 1987-88 of the Guwahati.
So where is that?
My lord, first, my lord, my affidavit, my lord, additional affidavit. my lord. If your lordship takes up,
Yes,
page 91, my lord. My additional affidavit dated 3/3/2023.
yes.
Page 91, down below, paragraph 4, my lord, which will, my lord, clarify the situation. That this deponent humbly begs to state that as per the Guwahati University's regulation for Master of Commerce, MCOM course and examination, effective from 1987-88 session, if a student after completion of his regular course of studies for the MCOM previous or final examination, next page, my lord, does not register himself as a candidate for or present himself at or fails to pass the examination immediately succeeding such completion under court, my lord, he may appear at any of the 2 successive examinations of the same standard, and for any further subsequent examination, he shall be required to prosecute a fresh course of study for the full period prescribed. Rule 18 of the regulations may be referred to. Next parameter. Further, clause 7.3 of the prospectus 2012-13 of the Ideal Guwahati University annexed to the read petition as Annexure 2 clearly states regarding examination fee to be paid for second, third sons back papers only. And as per clause 7 thereof, all examinations for Ideal students are conducted as per rules and regulations of the Guwahati University. Now, my lord, this is the regulation, my lord. Regulation for Master of Commerce course and examination 1987-88 onwards, my lord. Particularly clause 18, rule 18. (18)B, my lord. Internal page 6. It has been reflected in the affidavit, my lord, additional affidavit. In short, my lord, 3 chances
Just tell me.
within 4 years.
No, just tell me, in the first page of this regulation,
My lord,
it says for graduates of 10+2+3 pattern,
my lord.
correct?
Yes, my lord.
Now, you also say that the regulation at page 36 applies to him.
Yes, my lord.
So if it applies, it would be semester, how it will be an annual, what you call, the annual examination, what you call, protocol? How does it come?
My lord, in page 36, my
Because
lord,
for one student, 2 regulations will not apply.
my lord,
Either he's a semester student or he's a annual student.
my lord.
Where is that clarification? What stream he is in? He's a semester stream or he's in annual stream?
My lord, yearly mode, my lord. He is in the yearly mode, my lord, not in the semester.
So where are you saying that?
My
Because
lord,
if that applies, then page 36 will not apply on him.
my lord, he is of the, my lord, 10+2+3 pattern, my lord.
No, I understand, but the education pattern you are, it is your showing
My lord,
that it is semester system. So therefore, annual mode and semester system are 2 different modes.
different modes, ma'am.
So the petitioner is in which category? First, you must clarify that.
My lord, as per read petition, as per my affidavit, my lord, it is clear that he is in the yearly mode, my lord, not in the semester mode. and the regulations as well as the affidavit is clear about that. And my lord, both the semester mode and annual mode, yearly mode, my lord, has been, my lord, continuing at that relevant time. That is why, my lord, this idle prospectus comprises both the modes, my lord, yearly mode as well as semester mode. The prospectus, my lord, if your lordship again comes to page 36, my lord. Clause 7, my lord. Clause 7, my lord. Page 36.
Just fine.
Page 36, my lord, clause 7. May I read, my lord?
Page
Page 36, my
of
lord,
the repetition.
of the repetition. The ideal prospectus, my lord. Page
Yes,
36, clause 7. my lord. Examination and evaluation. The ideal Guwahati University is an integral part of the Guwahati University. All examinations for ideal students are conducted as per rules and regulations of the Guwahati University by the Controller of Examinations, Guwahati University. Any query related to the examinations may be made to the Controller of Examinations, Guwahati University through the Director Ideal and Guwahati University. So, my lord, the prospectus of ideal, it will be read together with the rules and regulations of the Guwahati University. Now, next, my lord, it is important. Rules and regulations.
Just now. Yes,
Rules and regulations, my lord. The last 6 lines. For master degree programs. 1. The MA, MSc, MCom, MCJ degree program shall be of 2 or 3 years duration and be divided into 2 public 4 modules, namely previous and final, and or first, second, third, fourth, fifth, and sixth semester examinations, which shall be held annually or at the end of every semester as specified in the respective syllabus. So, my lord, 2 streams
yes,
were continued at the relevant period, that is 2012-2013. One previous and final year, and another first, second, third, fourth, fifth, and sixth semester. So, my lord, the read petitioner is in the yearly mode. So, in the previous examination, my lord, 1 paper he failed, my lord.
yes, page 70,
Paper 2, my lord.
page 70.
My lord.
Yes,
So, my lord, he will have maximum 3 chances. He availed all the 3 chances. So, 4th chance cannot be, my lord, given to him. As per rules and regulations, as per, my lord, that ideal prospectus, which is clear from my affidavit, my lord, that additional affidavit. It was also clear. And
but 13, is it not contradictory? Rules and regulation number 1. 13 says a candidate will get a maximum of 4 academic years.
my lord, which is, my lord,
Oh. Mr. Nath, I think he has made a point. 4 academic years. If I am studying a MCom course in 4 academic years, I take admission in 2012. So my first year would be 2012, 13. So that is 1 year. It is included in the first term.
Yes.
And then you get 3 more chances. So in fact, clause 13 and clause 1 are same. 4 years, it includes 1 year academic curriculum which you have already undergone. If you get admitted in 1st January 2012, 31st December, your academic year ends.
Which year? I got admission on 26/9/12.
I'm just for easy what you call calendar calculation. I'm just taking 1st January. So first academic year ends on 31/12/2012. So then next academic year is 13,
13.
14, second and 15 is last.
May I?
So
interrupt,
fourth-
Milord? Milord, first year ends in 2013, Milord. Since 2012-13.
No,
The
just for easy
next-
calculation, you see, I'm not
1st January.
so good in arithmetic. I'm just for easy calculation.
Milord,
If we take 1st January,
Milord,
it ends on 31st.
Milord.
It helps me in calculation. Correct?
Yes, yes.
So therefore, 12, 13, 14, 15, 16, you don't get a chance.
Then what's the meaning of clause
And-
13?
No, that is why 4 academic years. It doesn't say 4.
It clearly says 4 subject. See, let me read again.
Yeah.
Candidate for MCOM, MSc something degree must pass all the courses papers prescribed for a particular subject within a period of maximum 4 academic year from the date of his enrollment.
So 4 academic years you calculate.
Hmm.
1st of January 2012 is 1 year, 12 is 1 year,
Hmm.
13 is 2nd year, 14 is 3rd year, and 15 is the 4th year.
Yes. Now let us calculate from
Milord,
exactly date of admission was 26/9/12.
26/9.
26/9/12.
So 26/9/13 is first year.
First year. Yes. So it will be 16, September 16, 4 years will be September 16. It's very clear from the clause 13.
Milord, I agree
4
with my
years.
learned friend, Milord.
If it
ends
is September
in 2016, but the keywords are 2 successive examinations. 2 successive examinations. It has been reflected in the rules and regulation of Guwahati University.
This is
2
for
successive
distance
examinations.
education.
So,
This
my lord,
prospectus is for distance education.
The first regular examination plus 2 successive examinations. That means, Milord, 3 examinations within 4 years.
13 that doesn't say.
On one part, Milord, I agree with my learned friend, Milord. It ends in 2016. It's all right, Milord. But within 4 years, it's all right. But he will have only 3 chances, Milord. 1 regular chance, other 2 successive chances, successive examinations. Rule 18 of the regulation. 4 years, but 3 chances. And that should be successive. By 2015, his chances are over.
Thirteen says from the
For
date of
final examination, he will have a chance in 2016. For final examination, he will have a chance in 2016. But for previous examination, Milord, 3 chances are over in 2015. Particularly as per Rule 18 of the MCOM regulation.
enrollment, 620. The 3 years. Reach this matter on 13/2/23, enabling the respondent university to apprise the court since when the maximum of 3 chances to clear the previous year examination of ideal was made applicable. That is the reason. Because of clause 13, because in earlier affidavit, entire fact was there, my lord, it was a knowledge. So that fact was noted by your lordships, my lord, and then this order passed, exactly since when the 3 years course came. That is not in his affidavit today. Because in the prospectus, how the students come to the university, they don't go to the rules, they will see what the prospectus. Now, for our own children, my lord, what we have done, we find out the prospect of the university, what are the courses, durations, fees, all these things, we go into it, and then we give them admission. Nobody goes to the university, Delhi University rules. No, prospectus is the main thing. It invites, attracts people, students, parents, send their students, children. And this cause 13 is absolutely clear, my submission is, my lord. And there's the reason your lordship has on last occasion directed him, since when 3 years course started. There's the reason, my lord. That order also, the second part, lordship, you try to understand whether such system of 3 years was made applicable to the students who took admission for the master degree IODL, Guwahati University, for the session 12 and 13. That is also lordship wanted to know, my lord, to solve this issue.
So for that, we have answer because these regulations are effective from 87, 88. So that would apply. Now, the only question is that
That part prospectus.
you are right in saying that people go by prospectus.
Yes,
We don't expect them to
go to the rules.
go to the rules.
My lord, in the prospectus, my lord, page 37 is regarding 4 years. But page 36 is regarding applicability of the rules and regulation of the Guwahati University, and page 40, my lord, regarding
Just-
3 chances.
Just one. Page 36, yes.
Is about the applicability of the Guwahati University rules and regulation, my lord, as well as the yearly mode. Yearly mode of examination. Page 37, my learned friend is right, my lord. Page 37 clause 13 is regarding 4 academic years, maximum 4 academic years. But page 40 is regarding second and third chance, not fourth chance.
Page,
Page 40, clause 7.3. Fees to be paid for second and third, not fourth. So the university stand is that it would be 4 academic years, but chances will be 3. And rule 18 is abundantly clear. 2 successive examinations. Rule 18B. If he fails to pass the examination immediately succeeding such completion,
we are reading where?
Rule 18, page 6, my lord, the rule and regulation, rules and regulation of MCOM, my lord, course and exams. Internal page 6, my lord, rule 18B. It is very relevant, my lord, the instant matter. May I read again, my lord?
Yes.
Rule 18B. If a student, after completion of his or her regular course of studies for the MCOM previous or final examination, here MCOM previous, my lord, does not register himself as a candidate for or present himself at or fails to pass the examination immediately immediately succeeding such completion, he may appear at any of the two successive examinations. These three words, two successive examinations of the same standard. So, my lord, maximum 3 chances, 1 regular chance after completion of his previous course of study, 2 successive examinations, 2 plus 1, 3 chances. But it will be within maximum 4 years. That ideal prospectus, page 36, 37, 40, as well as rule 18B, all have to be read together. my lord. And my affidavit is clear. My additional affidavit after the order dated 6/2/2023 of this honorable court to clarify the position.
Okay, Mr. Nata, I'll examine and pass over.
Obliged. Only one last one thing. Whatever rule they're saying, 3 years, 2 years, 2 exams, my lord, in the prospectus, they ought to have put it there in clause 13 along with clause 13. That's okay. I leave to lordship's matter. Obliged.
Most obliged.
My lord, this matter pertains to compassionate appointment of Chokidar.
Just now.
My lord. The fact is, my lord, for long I have not been able to contact the petitioner, my lord. I do not know the latest position of the petitioner, my lord. So I need to take some instruction, my lord. Let
Okay.
it come after 2 weeks, my lord.
Okay. No, it goes after BU because 2 weeks we can't.
It's all right, my lord.
From the prayer made by Mr. S.R. Rava, then counsel for the petitioner, the matter stands adjourned today. Mr. G. Bokalial, then government advocate is present.
Highly obliged, my lord.
Mr. Wadley, your bail matters will be taken up at 2.
Lordship, in this matter, Mr. K. Gogoi will appear. Lordship, he is on legs. Lordship, can this matter be taken up after some time, Lordship?
After some time. Okay.
Yes, Lordship.
Look, this is a case for suspension, well, the petitioner
Yes.
suspended in the year 2017. Till day she is still under suspension, well.
Okay. After some time.
Obliged, Lordship.
May I please, your lordship?
Just now. Who's for the Mr. Mazumdar? You'll be there, Mr. Sharma? You're there in the matter?
I'm for the secondary education department.
Secondary education, yes. No, this is elementary education. Who's there?
Your lordship, Mr. R. Mazumdar informed us that he couldn't file the activity in opposition till now, so he wants a date and he's not here right now. The matter may be taken after some time.
After some time. Okay. Well. Wait, please, your lordship. Lordship, kindly pass on the matter for the time being, lordship. Thirteen. There is no appearance from the petitioner or from the respondents in the elementary education department. No affidavit in opposition has been filed by the elementary education department. For respondent numbers 1 to 4 in this petition. Next, paragraph. By filing this petition under Article 226 of the Constitution of India, the petitioner has paid for question of the order dated 19/5/2018, passed by the Director Elementary Education with impact respondent number 2. By which the respondent numbers 5, 6, and 7 were promoted to the post of senior assistant. Next, paragraph. referring to the gradation list of junior assistants in the office of DEEO oblique BIS oblique BEEO apostrophe S under Dhemaji district. The petitioner projects that he had joined as junior assistant on 14/10/1989. But she received a regular scale of pay on and from 3/3/2003. The respondent number 5, Nirmal Kumar, was appointed as junior assistant on 27/11/1994,
May I praise Lord?
and on the same day he started getting regular scale of pay.
I'm
Yes,
extremely sorry, Lordship. I'm not available when matter was called for.
we are dismissing your writ petition.
Last occasion, respondent number 5 file affidavit in opposition by respondent number 6.
Yes,
I'll file rejoinder. Let me allow 2 weeks
you
time.
you can't do it better. You see, you come to your this gradation list which you have produced. Can you change facts by filing an affidavit? You have read 5, 6, and 7, Nirmal Kumar, Kushal Kumar, and then Antram Tangi. Both of them got regular scale of pay prior to you. Can you get seniority by any chance?
Let me allow 2 weeks time to file.
I
rejoinder.
understand you by filing it, what will do? You show me that you can do it. You look at your gradation list. From the date of regular appointment, both of them are senior to you. And by affidavit, you change the facts.
It cannot be changed.
Then this one. It is, and on the same day, at the IE 28/11/1994, the respondent number 5 got the regular scale of pay. The respondent number 6, Kushal Kumar Nyog, was appointed as junior assistant on 24/11/1987, and on the same day he got the regular scale of pay. Insofar as respondent number 7, Antaram Panging, is concerned, he was appointed as junior assistant on 12/1/1998, and on the same day he got the regular scale of pay in the pay. So therefore, considering the date on and from which the regular scale of pay was drawn by the petitioner, the respondent numbers 5, 6, and 7 are all senior to the petitioner. Next, Mr. U.S. Borgoin, and counsel for the petitioner, had paid for some more time to file affidavit in reply in the matter against the affidavit in opposition filed by respondent number 6. Court does not find any reason to grant such an opportunity on the ground that even by filing an affidavit in the matter, affidavit reply in the matter, the facts cannot be altered. There is nothing on record to show that merely because the appointment of the petitioner was in the year 1989, 1989. She would not be entitled to claim seniority position above the private respondents. As her position in the gradation list was never appealed. So there is no notification or no act rules or notification or record to show that seniority can be claimed on the basis of date of appointment and not on the date of drawing regular scale of pay. So under such circumstances, the court does not find any merit in the petition. And therefore, not only the prayer for filing additional affidavit reply is refused, but the reflection also stands dismissed. There shall be no orders to first. Mr. U.S. Borgohain for the petitioner. Okay.
May I please, Your Lordship?
Yes,
Lordship, in this case, we have to take first instruction from our client's Lordship regarding present status of their services. Lordship. I am appearing on behalf of Mr. M. Bhagwati. 2 weeks. Lordship, required, Lordship.
okay. On the prayer made by London Council for the petitioners, the matter stands adjourned today to enable her to obtain updated instructions. London Council for the BTC and Elementary Education Department are present.
My lord,
In
in
this-
the course list, it is shown as secondary education department. So my lord, I estimate that to show it as a elementary measure, my lord.
I don't know whether they are which department. This is elementary education.
Element. Yes. Press 8, my lord. In the course list, it is reflected as secondary.
Oh, acha. Okay, okay, okay. Next, the registration takes note that the rest all the respondents relate to elementary education department, and therefore the registration reflect the name of SC Elementary Education in the course list for respondent numbers 1 and 2 while listing the matter next. You are for elementary also?
No, I am on the secondary.
No patient call for the elementary education department.
My name may be my.
Okay. This after, how much time?
Weeks. Lordship, after 2 weeks.
No, it goes after view, okay, this after view vacations.
And your place.
Lordship, here in this matter, I seek for a week's further time, Lordship. I need to take the updated instructions regarding.
Affidavit of the college will also. be
Just a moment. You are aware of the present status? No.
My lord, I'm back in the college. The inquiry has not proceeded thereafter. No order has been passed there.
Milord, in this case, Milord, I am appearing on behalf of Milord, college authority, Milord, and governing body, Milord. Milord, some accommodation may be Milord granted to, in second item, Milord, we have already filed, Milord. Thereafter, one inquiry committee was conducted, Milord. So, Milord, I will rebut the statements and allegations, Milord, by the petitioner.
Okay.
Some accommodation, Milord.
Along with the
Also-
copy of the
all-
inquiry,
All sides are duly represented.
along with the records, my lord. If since they are appearing for the college, my lord, the records may also be called for, my
No,
lord.
let them first produce
Mine.
further affidavit.
My,
Uh, Records may be necessary, may not be necessary also.
Fine.
my lord.
My
You have seen the nature of pleadings you have made. We may not need that also.
Right.
All sides are duly represented on the prayer made by
TK Bhuya, my lord.
Mr. T.K. Bhuya, standing counsel for the, sorry, land counsel for respondent number.
4, 5, and 6.
My lord, I am
And-
for the Milord 4 and 5.
Sorry, 4 and 4.
I am appearing for the response.
Mr. T.K. Bhuya is for
I am for 4 and 5, my lord.
4 and 5. You are for
I am for the response 6.
6. Your name?
SK Deka.
SK Deka for respondent number 6. And Mr. D. Upamanya, Leonard, standing counsel for the elementary education,
Lordship, higher.
higher education department. Pray for and granted
Chief, my lord.
3 weeks time to file affidavit in opposition in the matter. So the said respondent shall note that notice of motion was issued by order dated 3/9/2018 and therefore almost 5 years is going to lapse. List immediately after the ensuing due vacation. This is an item 18. In the 19, you have already filed.
19, I will already file, my lord.
That's
Pleading
all.
complete, my lord.
Okay.
They file reply, my lord.
Item 19, all sides are represented. Submitted at the bar that pleadings are completed. So
In item.
take this matter along with item that along with WPC 5990/2018,
My lord, already the order is there.
list after 3 weeks.
My lord. Deeply obliged.
Obliged.
Deeply obliged.
20.
May I do, Lordship? Lordship, regarding the same issue, Lordship. Regarding the
Yes.
same issue, Lordship, a batch of cases are pending before the division bench, Lordship, and the matters are fixed on 3rd May, Lordship, for final disposal, Lordship. That may be, this matter may be fixed after that day.
Your name?
AMS Majumdar.
On the prayer meeting, say yes, AMS Mazumdar, counsel for the petitioner matters stands adjourned today. List after ensuing view vacations
After 3rd May,
after 3rd May.
Lordship. The matters are
And
fixed on
List the
3rd.
second week of May,
Obliged.
2020.
Obliged.
21. My pleasure. Lordship, this matter is for non-provisionalism of my service, Lordship. As advanced mathematics services, Lordship,
mandatory lordship. If the subject of the advanced mathematics is introduced in the school lordship, and I was declared eligible lordship in the result lordship, pursuant to format B lordship.
Where is that?
Lordship may kindly come to the page number 33. This is format B. Those who were deprived lordship for provincialization, there was a procedure to submit format B with Treasury Salon lordship. I submitted it on lordship Annexure L page 33 lordship. Salon is at page 32. And result was declared lordship, which is at page lordship 35. Page 36 lordship, 11% lordship. I have typed out lordship. My name is declared eligible lordship.
Who's paying for secondary education? You are there? Yes. What is the stand?
We are yet to receive the instructions.
The instructions will not come unless we impose cost. Give you 2 weeks time, otherwise we'll impose 25,000 each as cost. Both sides are duly represented. Miss, your name? H. Therapy. Learned, standing counsel for the secondary education department. Please for some more time to obtain instructions. Next, it is seen that notice of motion was issued by order dated 12/9/2018, but no affidavit in opposition has been filed. Next, accordingly, it is provided that in the event no affidavit in opposition is filed in the matter, at least 2 days prior to the next date of listing, the Commissioner Secretary to the Government of Assam, Secondary Education Department within bracket respond number 1, Director of Secondary Education Assam within bracket respond number 2, and the Inspector of Schools, Kamrup District Circle within bracket respond number 3 shall all be personally present with the relevant records and be prepared to render assistance to the learned standing counsel to respond to the court queries. That's why it is also provided that in the event no affidavit in opposition is filed and the respondent numbers 1 to 3 are not personally present, the court will pass orders on the next date to impose a cost of rupees 25,000 each on the said respondents for delaying the disclosure of the case, with liberty to the state to recover the same from their salaries. Next, the standing counsel for the Secondary Education Department shall transmit a downloaded copy of this order to the respondent authorities to bring it to their notice. This, you are appearing for number 4 also. 4 is the school. You are not appearing for school. Next, the standing counsel for the Secondary Education Department. submits that she cannot appear for the respondent number 4. Which according to the petitioner shall take steps for service of notice on respondent number 4 by registered post with AD, as well as by thusly by routing the process through the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph is Tom. 26/4/2023. Steps on 4.
Obliged, Lordship.
May I please, my lord? My lord, the issue before my lord is that
Why
after the,
taxes come here?
I don't know what. Maybe a relief from
My-
the
my education-
education.
My education itself is not complete. Yes,
One of the.
I think this is good. It has to go to bench 4. The tax
Bench-
matter is,
Otherwise, bench four.
it's a bench 4 matter. I think that would be appropriate.
Deputy Commissioner.
But my, subject to my.
Because otherwise, they are not entitled to share the liability of tax, I think.
Lordship. In
You're not
fact, from the contract terms, my lord, terms and condition of contract, we'll have to ascertain whether this is a works contract or it's a service contract. If there is a right to transfer of use, in that case, my lord, it will be a sale.
But
Then, my lord,
here
that-
there is no transfer, there is no sale, my lord.
Yes, that is.
And the tender did not require us to be a registered dealer.
in
And
fact,
none of this
my-
matter was all along coming in bench 2, my lord. That's what my friend is saying. All along in bench 2, my lord.
No, at that point of time, it was civil bench two. Now probably it has been changed, my lord, to
I don't
bench
know.
four.
No, but your department has not filed any affidavit.
My lord, I have got a short instruction is from examination of the agreement, we have found that, my lord, this particular, my lord, condition that has been stated by the petitioner, that they will have to be a VAT registered, my lord, bidder, that condition is not there. So probably, my lord, this deduction will not come in.
That's what I have a gut feeling, but I don't know since,
That's the, my lord, case.
but it has to go to the appropriate bench.
Lordship.
All sides, including, so you can hire senior counsel for the petitioner. And Mr. B. Gogoi Leonard, standing counsel for the
Taxation department.
taxation department are present.
Lordship, I'm for respondent of court.
And Mr. R. Taluja for AG. Present. D. Das Burman, government advocate for respondent number 6 and 7. Basically, heard so and so. Your name, just tell Mr. Gogoi, he can tell us.
V. Bora, my lord.
G. Bora,
What are for respondent number? For respondent number?
the agriculture department.
Agriculture.
Standing counsel for agriculture department.
Respond number 2. 3.
2, 3.
The registry shall take note that this matter relates to review of VAT on the bill amount of the petitioners. And therefore, it does not appear to be a matter covered by bench 2. Civil bench 2. Therefore, the registry shall examine if the matter relates to civil bench 4 and list the matter before appropriate bench.
Much obliged.
No, you're right. This is written here as bench 4, bench 2.
Bench 2.
That is why it is coming out for in bench 2.
Because earlier it was in bench 2, my lord. Maybe now it has changed.
Okay.
Earlier taxes were coming in bench 2. Much obliged.
23.
My lord, it's with regard to, my lord, if
You
lordship can
changed-
have this
you-
matter
you have
next week.
changed sides.
I've changed sides. 4, 5.
Lordship.
Oh, next week. Fine to us. Fine to us, next week.
Yes,
Lordship, I am for the 6 and 7, Lordship. So far as 6 and 7 is concerned, Lordship, they are no longer in their respective posts, Lordship. And principal and governing body, Lordship. And we are not contacted them, and after successor, maybe successor replaced, Lordship, they have not contacted to us till that, Lordship. So
they will not do it. They are not interested.
they will be directed to take fresh steps, Lordship.
Why should I direct them? You have taken a brief.
They are no longer in this post, we are unable to make.
No, you file your affidavit, you return back your brief fee. File an affidavit. Because you see, you have taken a brief for appearing for governing body and this college. Correct.
Governing body 5 and 6, no?
You
Six
did
and
not appear for any person.
Maybe yes, not. It's perpetual. Let me take you. Manu Thakur, no Thakur, you will have to be there. Can it be Namot as a governing body or Bapuji? Manu here, governing body or it was an.
Governing body doesn't it have?
He has not understood. He has not understood. Every time was any. Only prayer is.
Those were preliminary training where we had to read the entire, what you call,
CPC.
Guwahati High Court rules. Because without reading, I was not permitted to come into the courtroom. And that is why that chapter 5, rule 62 to 65, 66, this will be covered by 65, 66.
Now, my lord, water has flown. Now nobody has to read. Now only one interpret. Now it is only interpretation.
No, I don't know what those are.
Those were the days, my lord.
Uh,
My lord, only my prayer is if your lordship can have it next week or next week, maybe a little bit right after. My lord, my file got
No,
Displaced,
you see, the only issue here
lordship.
is the claim of that DPC.
Lordship. English to department. my lord.
Yes. The prayer is that they should have a grievance redressal mechanism.
Hmm.
Correct.
Lordship.
So what is there to oppose in this petition? He says that he has been getting some harassment.
Hmm.
In the hands of respondent number 4, he says that he is very influential. Head
But
of the
my lord, there
department.
is no material as such to bring. I am for respond number 4, my lord. 4 and 5 I am appearing. There is no material, my lord. That's what my thing was, my lord.
He says that some signatures were taken or something.
Yes.
DPC.
That's his, my lord. There is no proof for that, my lord. And secondly,
No, definitely, you see.
he wants a mental checkup of all the teachers. Why only for that school? Let it be for all the state, my lord. Same thing everywhere. These are not issues, my lord, which my lord would.
That is not, but yes, some mechanism where he can ventilate his grievance.
My lord, there is a mechanism. If he has any problem, the governing body or the college is not responding to that, he can always approach the director. Because the director is his appointing authority. Be there as it. The college is in under control, but the director happens to be under the provincialized rules 2005. He is the appointing authority, my lord. So anything is there, he can go there. If he does not get a relief there, 226 is his option, my lord. If it is relating to service matter. If it is relating to mental health, my lord, then I don't know.
So that is subject to satisfaction. Outside the
Lordship.
court, everybody thinks I am also.
We all have that problem. We all should be, my lord, if required. my lord. But that's not the way things work, my lord. Until and unless you can show that, yes, this man, because of his such conduct, is suspected to be mentally retarded, then, my lord, I think there's a provision in the CBC where he can approach the CGM also, my lord, to get CGM or some provision I read somewhere, my lord. Mental health thing, my lord.
That is more difficult now.
That's true. But provision exists, my lord, but procedure exists. And my lord, I am otherwise senior to him, my lord.
That is,
98, 99.
The procedure is a different procedure. One has to approach, be sent to the specialist and then they to the unit and then they appreciate under the Mental Health Act.
Lordship,
It's not like earlier. Under 87, it was Mental Health Act 87. It was the civil surgeon who would get that certificates.
now, my lord,
Now
it's
it is only the institutions.
where mental health is, like LGBI or something. Yeah, lordship can have it, my lord, next week, my lord. I just misplaced my file. That's why, my lord, I could not.
Affidavits are yet to be filed. None of the respondents.
Affidavit to file.
No, in this case. there
I
is
think it
no
has come
need
up
of
for the
filing.
first time. No, basically affidavit is required, my
It
lord.
doesn't require.
Require an affidavit. I think it has come up, my lord, after the first day today. my lord.
Yes, it's
Somehow, my lord,
it will also come
my
up
lord,
after
file
such a
got-
long time, Lordship. I also need to take instruction from my client, Lordship, whether Lordship any grievances raised in this petition, whether
No, if he
There
had
is
grievance,
success.
he would have tortured you. Don't worry.
This is, my lord, inter-college rivalry, intra-college rivalry.
It will
List
come
of
after 2 weeks.
21/4/2023 is
Right.
straight for by all sides.
Lordship, much appreciated.
He would have pestered you by now.
24 and 25.
Number 24. The respondent number 1 and 2 filed affidavit opposition on 23rd of March. I may be allowed 2 weeks time to file the reply affidavit. Like.
This is also covered by that same 2011
My lord.
Act provincial election
To
claim.
some extent, yes, but my lord, here there is a slight difference, my lord. What had happened is when we allotted posts to the school, we
The post was withdrawn.
Well, no, we had allotted 2 classical posts.
Hmm.
One should have been one classical post and one language post. Since we did not allot a language teacher, therefore 2 classical teachers were proposed to be provincial. So in fact, that had it been correctly given, perhaps you would have had a case. But since it was not done, again, Punabhati Brahma would come in, my lord. That is one aspect. Otherwise, my lord, there is another modification, my lord, an intelligence. Perhaps. My lord, there was an order by this honorable court that we had to file affidavits in both the writ petitions, failing which we would be liable to pay some costs.
One like each.
My lord, yes. Now, my lord, this affidavit that we have filed in the 2019 matter would also cover the 2018 matter. It was only, my lord, around day before yesterday when the file was given to me, I said that we were required to file in both, but then we determined, my lord, that it will cover both the issues. So, my lord, that
You want me to record that?
my lord, yes, that it will cover both, and therefore we are not filing on both, my lord. Otherwise, the liability of the cost, my lord, would remain.
Yes, that will come. You have filed the affidavit where?
And my lord, 23 and 3.
Okay. Mr. NJ Kadir and transfer the petition. Write separate order. then. Write separate orders. NJ Kadir and transfer the petitioner. Mr. R. Mazumdar, standing counsel for the secondary education department, has referred to the order dated 27/2/2023 regarding consequences of non-filing of the affidavit in opposition. And it is submitted that the affidavit in opposition in this case was filed on 22/3/2023 by the He said affidavit is on record. Next one. None of you. To be in a certificate manner, publication of the newspaper. In two newspapers. On the prayer made by London Canticles for the sorry, the London Council for the petitioner is from the praise for is granted. 2 weeks time to file affidavit in reply in the matter. Matter stands adjourned today. Let's start there. Ensuing view vacations. Now, in this second matter, right? Same had Mr. Spencer. By referring to common order dated 27 to 2023 passed in WPC 6252 2019 and WPC 1939 of 2018. It is submitted that there were consequences of not filing an affidavit in opposition in the matter. So it is submitted that in the connected WPC 6252 of 2019, an affidavit in opposition has already been filed on 22/3/2023, and the said affidavit shall cover the present case, present petition also. Full stop. Next, according to the London Council for the petitioner shall take note of the submissions made by London Standing Council for the Secondary Education Department. Here also you want to file affidavit?
Yes, my lord.
Just according to the praise for is granted 2 weeks time to file affidavit in reply in the matter in this petition based on affidavit in opposition filed in WBC 6252 2019. Next list after answering. Give away questions.
I am appealing for respondent number 3.
Respond number
3.
is DD Barman, government additional senior government advocate appearing for respondent number 3.
Published.
Your lordship, I want to your lordship and I'm extremely sorry to interfere between the court proceeding. Lordship, in item number 50, lordship, I have filed an additional affidavit on 23 of March, lordship. Kindly call for the record, lordship. Of that.
This SB Chaudhary and Council for the petitioner. Mr. D. Upamanel as Standing Council for the Higher Education Department has referred to the order dated 24 to 2023, wherein the Director of Higher Education Assam, respondent number 2, was directed to seize the entire records of inquiry made by the authorities of Gardhan College, Simlaguri. And to place the same before the court. He prays for and is granted 2 days time to obtain instructions and produce the records. List on 31/3/2023.
Published.
27.
Person to an advertisement, my lord. He was selected in the meantime.
Just. Yes, who is appearing for finance?
Finance is impleted, my lord.
Second one.
I was filed to implement the,
Have you given
Thank you,
copies to the finance?
yes, my lord.
Copy of representation
Copy-
is served.
copy served, my lord.
Uh, Mr. A.K. Dattal and counsel for the petitioner submits that he has served copy of the writ petition to Learned Study Council for the finance department. Next for the cause list does not reflect the name of SC Finance. Hence, let the matter be listed on 29/3/2023 by reflecting the name of SC Finance on listing the matter next. Okay. On the next date, you remember, you tell us that we issue notice on the finance notice has not been issued. Correct. Remind me on the next date. It is being listed day after tomorrow. And you inform the SC Finance to be here.
So, otherwise, my lord, in WPC 7006 of 2015, in somewhat similar circumstances, this honorable court had ordered the appointment to be given after taking the concurrence of the finance.
Yes, you are referring here because I am yet to issue notice on finance.
Yes.
Then don't write that. Just say. Letter notice. Returnable in 2 months. be issued. In respect of the newly integrated respondent number. So and so. Finance department, huh? Side of the List the matter after 2 weeks. You get the information.
Yes,
because
Lord.
if SI approval is required, then we can
I'll get the
dispose
status.
of the registration.
Number 5, time being.
Mr. Datta. Mr. Datta. We are listing it after view vacations because this second week will be just during the program. After list immediately after view vacations. Yes.
My lord, my senior is still on legs and got to.
Which one?
10. Item number 10.
The respondents are also like the remote of the filtering for the agenda will be done within 10 minutes.
Lordship is still in court number 17, Lordship on Lakes, Lordship.
11.
Last occasion, my lord, honorable courts by order dated 10/3/2023, my lord. No court directed.
Yes.
No, the part of this matter, the subject matter is also under consideration by the division bench, I'm told, by the department. Therefore, I could not arrange for the affidavit to be filed, but lordship had observed that no further adjournments will be given. Since this aspect as to the number of teachers who are required to be provincialized under the act, we had limited it to 3. That is one of the subject matters before the division bench where the entire provisions of the act have been challenged. That is one of the provisions which is being
No,
challenged.
you see, challenge is one part,
Yes,
but there's no what you call stay of the operation of the rules.
no,
Once it is not there, then appointment has to be made,
yes,
whether you like it or not.
yes.
The division bench, I think, may not have stayed the operation of
It
the
is not,
rules.
it is not instant. It is not instant because they have challenged it. They want it and to go entirely because they have not been given the benefit of under the Provincialization Act. So their challenge is that it should not be 3 posts, it should be more, it should be according to the number of students. That is the challenge. Therefore, my lord, I could not bring on it. Otherwise, my lord,
Then what we do is we proceed to hear the matter and then pass orders. Because if there is no stay to the that provision,
my lord.
then the interpretation would be that the posts are to be filled up.
It should be whether the interpretation of that particular provision matter.
Pardon me?
Interpretation of the particular provision matter that will be.
No, you see,
Whether we.
let me put it in another way. The challenge to the virus of the this act 2000 what do you call the
17 provincialization.
2017 that act has got nothing to do with the interpretation of that of this schedule of the 2000 what do you call the 2009 right to the Education Act. Correct. It has got also got nothing to do with the number of posts which are earmarked against every subject.
Since
So
we
therefore, the
were,
subject matter before this court in this
Since
writ
we were
petition
taking
is
up
not
only one-
directly or indirectly an issue before the division bench.
since the challenge before the division bench is keeping it restricted to 3 teachers is arbitrary and is the wrong interpretation. And that is what has been projected before the division bench also.
No, if it is a wrong interpretation, there cannot be. If it's a wrong question of wrong interpretation, then the virus of the act would not have been challenged. They would have made a prayer.
This is the correct interpretation. In my opinion, also this is the challenge should not have been before the division bench was also my opinion.
Because it should have been a case of reading down the act to
Yes.
include the
Other
more
posts.
posts. Once it is a challenge made,
Since the subject is before the division bench, the division bench has classified around 6 groups.
No stay there.
On different subject matters. So one of the subject matter is whether the number of posts are limited by the 2017 Act, and if it limits, whether that is arbitrary or impartial.
You have a copy of that order? Can we get it?
Chart
At 2 o'clock?
have,
Give me
my
the
lord, I
number,
have
we'll,
I have in my mail, I'll put it.
you give me the case number, we'll get out from
Or,
our registry.
I'll give a copy, my lord. Alternatively, my lord, could it be so done that this matter is taken up on some other day for hearing? I will not press for a affidavit in opposition. I will have a discussion with my other colleagues who are actually handling the provincialization cases on this level. So with the discussion, my lord, it can be taken up for hearing on any other day. In the meantime, today itself, I'll give the list prepared by the registry on the classification of the cases.
We'll take it up on Friday then.
This Friday.
What says it will be represented? Mr. R. Mazumdar and his training counsel for the secondary education department.
Yeah.
Place for some time to address this court. Accordingly, matters stands adjourned today. List on Friday 31st March.
I'm obliged.
Well, because Mr. Mazumdar, although I have adjourned the matter, but if the Act says the prescription of the Act is that it has limitations for the appointments. The challenge to that is something I could not understand. But then there's no requirement to challenge it, because now if it is challenged and everything goes, then the appointment which they are seeking will never come.
Yes.
Ideally, it should have been a reading down of the Act as it is to include more posts. I have still not been able to follow.
What they have done is, madam, along with this section,
No, because why that exercise of subclassifying the issues and then trying to find out whether whether there are more posts in a challenge to the virus of the Act? Why that exercise is required at all?
there were around 167 cases filed before the division bench, honorable division bench.
No, that is okay, but I'm just
Then
trying
we
to
can-
understand.
Try to find out the
I'm
challenge.
not questioning what is happening. I'm just trying to understand. Why the classification if the virus is under challenge? That is an exercise which will not help the
Petitions.
court in any way.
Maybe those cases, again, maybe certainly not being a challenge to the provision of law, but issue of interpretation, we may be remanded back also. But classification has been done in such a manner.
Maybe a question. Well,
Yes, 12. Mr. Ahmed.
Allotment of dice code, my lord. Petitioner school has been allocated.
Just
Maybe a question. This is my lord, regarding allotment of dice code, my lord.
no, who's going to- Yes,
Maybe resolution. My lord, this is regarding my lord allotment of dice code, my lord. The school of the petitioners have been, my lord, verified, my lord, and allotted dice code for the year 2016-17, my lord. But our claim is that, my lord, we should be given a dice code for the year 14-15, my lord.
14, 15.
Yes,
Yes.
because we applied for 14-15, my lord. Due to, my lord, late verification, my lord, dice code was allotted lately, my lord, and accordingly it is given to 16-17, my lord. Here is the order, my lord, I have given, my lord. In similar cases, my lord. Matter was referred to the, my lord, mission director to reconsider, my lord. Small order, my lord. If entitled, they will give, on. If not entitled, then they will not.
Mr. Nayak, you are appearing the matter.
For SSA lots.
It will be covered by this order.
Lordship, only thing will be lordship, he is paying for a dias code for the year 2014-15 lordship. And lordship, so far as my instruction is concerned, lordship. Lordship, one organization called National Institute of Educational Planning and Administration. They maintain dias code, lordship. They are the authority, lordship, to maintain the dias code, lordship. And now, lordship, it is not possible for us to open the network again, lordship. It will not be for us to open, lordship. If their party here, lordship.
Oh, they are authorities who are working under you.
No, lordship, it's a central government organization, lordship. Earlier, this organization was maintaining the dias code, lordship, till 2017. Now, lordship, it's Union Human Resource Affairs, lordship. Now
They are maintaining it.
Yes, lordship. Now their participation is their, view is necessary, lordship. We only upload, lordship. The school authority concerned, lordship, they submit, lordship, we upload. Once it is uploaded, lordship, then we are not the authority to reopen it again, lordship. If they can, lordship, it's up to them, lordship. So their response is necessary.
Now, even if you try to upload, you are trying to
It
say
will
that
not
it will not go.
Not, it will not possible. We cannot open it also, lord. I will make party member. I will tell you, bring him to make party member.
And who is the authority in the central government to do it?
Now it is lordship Ministry of Education from 2018-19 lordship. Government of India.
The relevant time, who was there?
Up to 2017-18 lordship, it was National Institute of Educational Planning.
Just a moment.
National Institute of Educational Planning and Administration. Educational Planning and Administration.
After 2018?
Up to 2017-18, they were maintaining lordship.
Yes.
Thereafter, lordship, it's the Ministry of Education, Government of India. Lordship, may I pray, lordship?
And just one more thing. Now, after this order was passed on 2020.
Lordship, earlier, lordship, some orders like this were passed by this honorable court, lordship. But I think this order was reviewed subsequently on being an affidavit filed by the SSL, lordship, in later cases, lordship. Lordship, I am praying at this stage, lordship, though it is late, lordship, it's a matter of 2018. Lordship will grant me some opportunity, lordship. 2 weeks, lordship, I will file an affidavit, lordship.
Just note your submissions, because
Lordship.
otherwise, if you can impede them, that is good.
That is it,
That will save some time.
lordship.
For Mr. H. Ahmed, I'm counsel for the petitioners.
Affidavit file also.
And Mr. P. Nayak, learned standing counsel for the Assam Service Shiksha Mission, correct?
Lordship.
You have Assam Service Shiksha,
Now it's Samagra Siksha, we can note it. SSA,
Assam Samagra Shiksha Abhijan Mission,
SSA Assam, Lord.
Huh?
SSA Assam.
within bracket SSA Assam. I submitted that. He's aware that this could by various orders, including order dated 12/2/2020, passed in WPC 1602 of 2018. Had directed the allotment of DIAS code for the period 2014-15 if they were otherwise found eligible for allotment of DIAS code. However, without giving any financial benefit for the said period. First of, however, it is submitted that he has instructions to the effect that till the year 2017, the preparation of DIAS code, DIS code was being done by the National Institute of Educational Planning and Administration, New Delhi. So, however, after 2018, since 2018, the work of preparation of the DIAS code is handled by the Ministry of Education, Government of India. First of all, it is submitted that under the present regime, it is not possible for the SSA Assam to upload any DICE data for the period 2014-15. So hence, he suggests that the Ministry of Education, Government of India be also impeached in the matter. Yeah. So he also prays for at least 3 weeks time to obtain updated instructions in the matter and to file affidavit in opposition if required.
Lordship.
Next para, the learned counsel for the petitioner shall take notes, petitioners shall take note of the said submission and do the needful if so advised. This is matter after view vacation, give a date, fixed date after view vacation.
21/4.
অলপ দেৰিকে দিয়ক
21/4.
একদম বিহুতে অলপ দেৰি হয় শেষৰ পৰা 28 29 চিনেমা
29/4.
Lordship, it's a 2018 matter. Petitioner will submit a copy of this petition.
28/4.
Obliged, sir.
Lordship, this matter has been complied with, but the compliance report is with Mr. K. Gogoi, Lordship. So he will, Lordship, will submit the 29.
Lordship, in this case, we have to do the release of part, Lordship.
I'm appearing for the AG Lordship. 2 weeks time may be granted because matter can be settled out Lordship. Old matter, the file does not trace out. Yeah, that's why we need 2 weeks time Lordship. We'll be able to settle the matter Lordship within 2 weeks time Lordship.
Okay. None of you call for the petitioner. So Mr. Dio permanent and counsel for the which respondent?
I'm appearing for 2. The
For one.
accountant general.
For respondent number 1, submits that the respondent number 1 has complied with the order of the court. Next, madam, Mr. B. Chakravarti, run a counsel for respondent number 2.
2.
Respondent is granted 2 weeks time to obtain updated information as regards compliance of the matter. Let's go. Matter stands adjourned today, based on after view vacation.
Lordship, I'm for the respondent number 3.
Your name? Your name?
C. Talukdar.
We didn't get it. Your name?
SC Taluk.
SK Talukdar.
Oh, C Taluk.
Correspondent number 3. List on
28-4.
28.
Hardy.
I am for the private respondents, except 7, 3 to 21. Huh? Affidavit আমি দিছি। Comment দিয়ে লিখে দেবো। This number.
Who's appearing for the respondent number 1?
Assam State Council.
1 and 2?
Sustaining.
SCRT.
I'm sorry, man.
It's okay.
The private respondent filed the affidavit, government hasn't filed affidavit till date, my lord. The matter related to government, let them file the affidavit.
Where is your affidavit?
Date to go there. Date to
Yes,
go.
what is your stand in the affidavit?
My lord, their claim is that no, my lord.
Stenography test was held.
Not held, my lord.
Yes.
It is not mandatory. Advertisement does not disclose, my lord.
No, but to engage a stenographer, you don't need a test.
My lord, that is not there in the advertisement, my lord. So government has to file the affidavit.
And the
But government has not taken.
clearly stated that stenographer
This,
shortened.
nobody else but us will understand the importance of a stenography skill for a stenographer.
Yes.
The qualification is there, 80% speed, my lord, 80 per hour speed, my lord. And they mentioned the institution also from where they have to pass. Yes. সেইটো নহয় নহয়। কি লিখছে এইটো? pass.
He has to pass the shorthand test.
Yes,
Shorthand test.
he has to pass. So this advertisement, that's why I say, because to engage a stenography, it is without test, privacy will have to dismiss the, allow the repetition.
একো নাই দেখি, তুমি যিখন চাইছা।
Mrs. Burman, this repetition has to be allowed.
Having fluency in English,
Hmm.
he/she has to pass the shorthand test. Minimum speed
per minute.
one should have is 80 words per minute. Graduate in any stream having diploma in shorthand writing from Industrial Training Institute by Assam, in Assam by NC, National Council for Vocational Trade, diploma in stenography. He has to pass the shorthand test. Is there in that?
It has to be because you see, nobody can understand that more than us.
They're testing the shortened test, they have appointed.
Mrs. Burman,
Hello.
you be there till you are, but we'll have to direct a fresh.
Well, sometime maybe even I'll go through it man properly.
But this we have gone, that's what I'm saying. Nothing,
Let the
nothing,
matter be listed for admission, my lord, next week.
nothing is there in this case. It has to be allowed in.
30.
16 method.
This request has to be allowed.
But not, SCRT name has not been shown in phone. Let me go to, SCRT name has not been shown in the cause list. That's all.
Name is not shown in the cause list.
It doesn't matter. Yes, yes, don't know. We will post it in next week, but in the meantime, everything goes to the.
Not next week, we'll keep it on 31st.
Lots,
Is a 2016 matter.
lots.
Yes,
Mr. M. H. Ansari and counsel for the petitioner is present. The petitioner is present.
You know,
Also, right, Miss, in same vein, so and Miss, Mrs. P. Burman, and counsel for the respondent numbers 4 to 6, 8 to 15, and 17 to 21 are present. Also respond number 3 to 6, make it 3 to 6, 8 to 15, 17 to 21 present. Mr. S. Bora and standing counsel for the
number 2, madam.
respondent numbers 1 and 2 submits that he has missed the matter as his name was not included in the cause list. Next, it is noted that although
Nine.
notice of motion was
641.
issued by order dated 29/1/2016. No affidavit in opposition has been filed by the respondent numbers 1 and 2. It is also noted that the grievance of the petitioners is that appointment of stenographers were made without complying with the requirement of advertisement to have a skill test of stenography. Next, the registry shall reflect the name of SCERT while listing the matter next. Next, even if the name of the learned standing counsel for respondent number 1 and 2 is not reflected in the cause list on the next date, I will take note that this matter is ordered to be listed on 31/3/2023. As per list accordingly. So even if it is not listed, not your name is not shown, we take note.
Lordship, 31st.
And Mr. Ansari, if his name is not shown, you inform him day before. Correct, over phone.
Date may be fixed.
31st March.
Must be.
31.
But then, matter may be taken at 2 PM possible.
The respondent has already expired. Nothing will happen at 2 o'clock.
It's not, in this case, the government also filed an appeal before the Honorable Division Bench that was dismissed.
This is contempt.
Lordship.
This is contempt petition.
Aye.
Respondent one has already died.
Yes, Lordship. I will be allowed to impede the, I will be allowed to impede the.
On the prayer made by the counsel of the petitioner is permitted to impede the present incumbent as respondent after putting him to notice of complying of putting notice to comply with the order of the court. List along with the impeding application.
33.
We have some.
Yes.
Lordship, in this case, I am appealing for respondent 5, but since filing of my Ukalat na power, I have no contact with this person. Lordship, in this, otherwise, apparently this case appears to be in fact, in the last occasion, while case was listed before Honorable Court, when learned Department Council has submitted an order passed by Director of Higher Education. From that, even if this order goes against me also, but without challenging, nothing remains. But without presence of petitioner side, whether it would be. Otherwise, recommendation was in my favor.
None appears on call for the petitioner.
Lordship, kindly have a look for a moment, page 40, annexure 13 million. That was the recommendation by GB in my favor.
That was declined.
Lordship.
That was declined.
That's why I'm saying, because even this order also goes
No, I'm
against.
just noting your submission because the petition is not there. I'm not discussing today. But it will come in admission hearing then.
Orders, Miller.
Today it is an orders.
Order.
Now it will come in admission hearing.
Lords,
Mr. M. Ansal, Council appealing for respondent number 5. Yes.
but the Lordship,
No,
one thing, Miller, this-
You are for the
Department.
So I'm writing it in your name,
Yes.
not in his name.
because this,
It was placed by the
this
department.
communication
No, it's
was
okay, okay.
collected
I
from.
get it. No, I get it. I mean, this- Mr. M. Mahathir and counsel for the private respondent number 5 is present. Next one, Mr. D. Upamanir and its standing counsel for the higher education department. Upon instructions has submitted that by an order dated 6/6/2018, the Director of Higher Education Assam had heard the dispute regarding the petitioner and respondent number 5 for the post of junior, for the post of selection and promotion to the post of junior assistant. And it is submitted that as the petitioner as well as respondent number 5 were not having the minimum qualification required to hold the post for being upgraded from the post of laboratory bearer to junior assistants. The proposal sent by the principal, Rangia College, was rejected. Next paragraph, be that as it may. As the counsel for the petitioner is absent on call. And having noted that he's on an action conference law, the case is ready as regards service. According to this matter, will be listed in the admission column immediately after the ensuing view vacations. The instructions produced by the London Standing Council is returned.
Obliged, Lordship.
In this case, my lord, notice was not issued to respondent number 7, my lord. Notice was not issued to respondent number 7, my lord. That is the position. Okay. Mr. H.R. Ahmed and counsel for the petitioners. He has pointed out that inadvertently the notice was not issued on the respondent number 7. So accordingly, let a notice returnable in 3 weeks be issued on the respondent number 7. This government advocate will appear, you will appear for respondent number
I'm
7.
appearing for elementary, my lord.
No, but the screening committee,
I have a little prayer, my lord. Madam, will be kindly listed on 28/4, my lord.
No, please don't complicate things. Ms. Barman, as this respondent number 7 is screening committee. Dhubri district represented by chairman cum commissioner Lower Assam division.
Yes.
So you will have to appear for them.
Yes,
Yes. D.D. Barman, then an additional senior committee advocate, accepts notice on behalf of respondent number 7. So requisite extra copies of the petition be served on her in course of the day. Yes, for elementary education, what do you have to say?
My lord, all the similar matters has been fixed on 28/4, my lord. All the illegal, irregular matters.
Okay. The Learned Standing Council for the Elementary Education Department submits that similar matters are all listed on 28/4/2023.
My lord.
Let this matter also be listed on the 28/4/2023. So all the respondents are at liberty to file their affidavit in opposition, if so desired within at least 1 week prior to the next date of listing. This is the registry shall reflect the name of GA Assam. Appearing for respondent numbers 2 and 7 while listing the matter next. No, on this one, 2 is elementary education. You will appear for
I'm appearing for respondent. numbers.
1, 2, 4, 5, and 6.
No, my lord, 2, 4,
Sorry.
5 and 6, my lord.
Your name?
And Fukan.
M. Fukan. Study of the elementary education appears for respondent numbers 1, 2, 4, 5, and 6.
My lord.
Okay. GSM for respondent 2 and 7. So for respondent 7, not 2. Listing the matter next. Okay. Obliged.
RT5.
This is the admission count. Yes.
Lordship, by order dated 29/4/2022. By order dated 29/4/2022, Lordship, there was a direction from the Honorable Court, to the state government, to furnish instructions as to whether the review petitioner's case is covered under WPC 335 of 2013. The matter here pertains to, your Lordship,
Order of which date?
the order, your Lordship, at page 21.
No.
Yes,
Order of this court dated
or 29/4/2022.
29/4. Okay.
Yes.
Ruben, I will, ইয়ার ইস্যুটা বেলেগ হয়ে আছে, whether it is covered or not, এটা খুবই পরিষ্কার।
You have a copy of the judgment with you? You have a copy of the judgment with you?
The order,
This 353?
yes, your Lordship, it is annexed in the writ petition, your Lordship. It is at page 21. Page 21, your Lordship. The portion starts at page 22. That happened, your Lordship.
Where is the order under
Yes,
the order under review? Where is that?
It starts at page 11, your Lordship. Page 14 contains the particulars of the current writ petitioners, review petitioners, your Lordship, and the order starts at page 19. Page 19 is where the order starts. Page 14 is the cause title of the review petition is your lordship. The matters were tagged together.
But then also, what you call, no case will be made out for review. You see, the reason being very simple, that the previous order of the court was not placed before this court. Correct.
335, your lordship.
Yes.
It was considered, your lordship. 335, WPC 335 was considered, your lordship.
Where is that?
If your lordship can kindly come to the last paragraph at page 19. In similar circumstances, that is on identical grievances, this court had the occasion to look into and decide the issue in WPC number 335 of 2013. And 335, your lordship, of 2013, if your lordship can kindly come to page 22, just for a moment, your lordship, page 22. The last paragraph. WPC 335 2013 was decided on the premise and the fact that the petitioners were appointed by orders issued in March 2001, and to be precise, on 12th of March 2001 as assistant teachers of high school with a monthly salary of so and so. Our case, your lordship, is that we were appointed on 31st of March 2001, and the ban was lifted on 25th of March 2001. So although the prayers of the writ petition in the underlying review order, your lordship, was similar, the facts of the petitioners are slightly different. And in that regard, your lordship, that this honorable court directed the state government to file an affidavit and to bring on record the instructions as to whether we fall under the same purview or not. We were appointed pursuant to the same advertisement, but we were appointed after the ban was lifted. And the footing is not identical, your lordship. Similarly situated candidates. Are you in touch with the clients? Have been drawing the regular scale of pay, and we were granted fixed scale of pay. And that is why we prefer the writ petition before this honorable court.
Where are the orders of your appointment?
Yes, your lordship will kindly come to page 44, your lordship. Page 44 of the review petition. Just to inform the court, the appointment orders were also appended to the writ petition also. In the review petition, your lordship, it starts at page 44. 45, 46, and 47.
No, but you see,
Yes, your lordship.
in this, this page 44
Yes, your lordship.
to 47 discloses that you are appointed on fixed pay.
Yes.
So how can your status be changed by virtue of court order
So what has
to make
happened, your lordship?
it, to make you entitled to a scale of pay?
The pursuant to the same advertisement, your lordship, we had approached this honorable court on an earlier occasion, 2001, challenging the order of appointment as well, because the similarly situated first batch of appointees have been drawing the regular scale of pay since the date of appointment. We were not granted that. Pursuant to the interference of this honorable court, your lordship, we were granted a regular scale of pay from a belated stage in 2011 on. Thereafter,
Where is that?
yes, your lordship, that is a part of the writ petition. That is a part of the writ petition. The writ petition may not be before your lordship. And that was assailed in the writ petition, the fact that we wanted a regular scale of pay, including current and area salaries within the state.
Just
40, yes.
45. Pradeep Gogoi. Parul Dotto আছে। Even করে 40, 45, 13, 16.
That's 65. That's 65. Around 13.
And they've accepted this.
Around 40.
That is order passed in WPC 3796/02.
Your Lordship, the order dated 6/12/2001 in WPC 4838 of 2001. That is the order, Your Lordship, where you challenged our appointment orders.
Four eight three eight 2001.
One,
You say it is in the red petition.
it is in the petition. If Your Lordship can kindly come to paragraph number 10. It is appended at annexure C in the writ petition. Annexure C.
That doesn't help you. You have a copy of the writ petition.
I have a copy of the writ petition which is appended to the writ appeal, Your Lordship. I have it handy, Your Lordship, but it will be inconvenient.
But
for
you
Your
see this order,
Lordship. Yes, Your Lordship.
it's only an interim order to pay their salary in accordance with law and rules, nothing more. You take the second copy of the writ petition.
Yes. If I can read my pleadings, Your Lordship. I can 8 to keep going for them.
Page 24 is the order.
Yes. After we revision, it is possible.
Mr. Mazumdar, see that also, page 24, look at that, you may not have it. Page 24, it's only an interim order, the petitioner be paid their salary in accordance with law. Because Mr. Sharma,
Yes, yes,
what I understand is that
yes,
when your status is changed from fixed pay
yes.
to skill pay,
Skill pay.
then there must be an authority, order from the appropriate authority, and that your appointment must be made in the regular course of the employment process. That was never there.
It was never there, Your Lordship. Against this order of this honorable court, Your Lordship, we had again approached this honorable court. If Your Lordship can kindly, if I can read out the order, Your Lordship, the subsequent WPC which was filed. What has happened, Your Lordship, was that the advertisement dated 28/12/1996. There were large scale discrepancies in terms of the vacancies and. So the decision to allocate the review petitioners as fixed pay, in fixed pay, was a matter of policy. The advertisement, Your Lordship, nowhere stated that the review petitioners would be entitled to a fixed pay. There was substantive post in the state government. The entire state saw large scale malpractices involved in the appointment, Your Lordship. Thereafter, the second batch of appointees that were appointed against the vacant posts, they were discriminated against and put into fixed scale of pay. This matter, when it was gone into by this honorable court, that is the reason the honorable court has directed the authorities to furnish the status as to whether our appointment was against vacant seats or whether our appointment was in excess of vacancies. Because what has happened in certain districts was that there were vacancies to the amount of 6 seats or 7 seats. And there were around appointments of around 200 or so. It was in that regard that the entire policy of fixed pay was brought into picture.
No, but still I have some reservations. You see,
Yes.
if you come to page 32 of the writ petition,
Yes, yes,
that is order dated 21/2006
yes, yes.
by in WPC 3796
Yes.
2002, correct?
Yes.
Here also your right has not been determined.
They were
The
not
court-
even parties in the petition.
No, question of parties not being there or not being there may be civilly situated, but the problem is that even if the court orders
Yes.
a change of status, it is not the court who is the appointing authority.
Absolutely.
It would only be the authorities in the education department who
Yes.
are appointing you.
Yes.
So the change of status must be, you see, a finding. Otherwise, you know, the principles of sub silentio. If there's no discussion on how your right has been adjudicated, then you don't get that benefit.
Absolutely, Your Lordship is very correct in this.
Our intention, your lordship, behind preparing this review, humble submission, your lordship, is that if this honorable court would have taken note of the difference in stand of the appointment date of the review petitioners, maybe that day, your lordship, on 22/4/2015, this honorable court would have de-tagged our writ petition and heard the matter separately. That is the only submission I can make before this court. And that is the only point of contention before this honorable court, that this matter be remanded to the single judge and the matter be looked at from that point of view, that sole point of view. We don't have any other case, your lordship, because the matter has been decided based on a.
No, that would only be an academic exercise. You see, if what I'm
Yes,
saying
yes.
falls in place, right, it would be a correct logical approach. Because I don't know whether what I'm thinking is right or wrong. It is for you, both of you, to address the court.
Yes.
You see, if the line of thinking which I'm having is the correct approach, then also even if the writ petition is de-tagged, it gives the same result. Because you see, yes, the change of status is something which is paramount. How it comes to existence, and whether if merely because the court says so. You see you see what has happened.
Yes.
These are all what you call scheme, which I am unable to understand.
Yes.
You see, I have shown you the order.
Yes, yes,
It merely says that you make payment
yes.
of the salary. Now, in this order, 3796/02,
Yes,
you see a view is taken
yes,
that with in middle somewhere it is written 26/8/05,
we're
which
entitled.
was resolved, issued a direction writ petition in so and so, entitled to go for regular salary.
Yes,
Regular salary was not there. Salary in accordance with rules.
salary in accordance with rules. In fact, from.
So once you are, you see, when the appointment letter says it is a fixed salary,
Yes,
then merely because it says that it shall be in accordance with the rule will not make your appointment a regular appointment.
your lordship will kindly come to page 49 just for a moment, just to clarify your lordship's query here.
It is 49.
Page 49 of the writ petition, your lordship. We have made an amendment also that pursuant thereto, the director of secondary education.
So
While
just a moment, 49 in the writ petition may not be
Yes.
there.
49 of the writ petition. Okay.
Review petition.
No, your lordship, writ petition.
Writ petition only has what you call 35 pages.
Make sure.
Maybe you are holding a copy of the writ appeal.
I'm holding a copy of the writ appeal with the writ petition, your lordship. In fact, we have gotten the graduate scale of pay since 2011.
But you see, I have given you the second copy of the writ
34.
petition.
34 of the writ petition. 34 of the writ petition is what is referring to. 21st of June 2011 from the person. Huh? This is what was doing.
This is a part of the writ petition. In fact, if your lordship can kindly see paragraph 13 of the writ petition.
We can't declare this. Page 34. Petition of 34, 49 request, no petition of 34, include 49 page.
Page 34, I beg your pardon, your lordship. Page.
Yes, I have seen that.
Yes.
I have seen that.
So now they have taken a contradicting stand themselves, the state government. And
Mr. Sharma, as I have told you, I don't know. I'll give you time to prepare and make your submission. You see what is happening. The interpretation I've shown you in that order is to give you pay in accordance with rules.
Yes.
That is projected in 3796 as if there's a direction to pay regular scale of pay. Then what happens is that because of the direction, a contempt is filed. And in contempt, very conveniently, an order is passed to appoint you in a regular scale.
Yes.
But that is not the scheme of the appointment. You could not have been given that service.
One aspect is not being projected, madam. The interim order that case in which the interim order was given was withdrawn.
Is it?
Yes, and the final orders which are being shown now, where the regular scale of pay is coming, is with regard to some other petitioners.
Some other petitioners, they are not
So
there.
therefore, the page 34 with regard to those petitioners.
No, no. You
Once
see, his case is that this matter could have been retagged and heard separately. Correct.
Yes,
That is what his now position
yes.
is. But it doesn't change the situation.
But
What
then
I'm
he has to
trying say-
overcome his withdrawal on the first occasion. When he had the
Which-
same prayers,
Which your order
page
withdrawn?
12, para 11 of the read petition itself. Read petition, page 12, para 11. If he gave up that litigation at that point of time, can he now come back with the same prayer? The prayers are the same. That Lordship will kindly come to page 11 first. What was the prayer in the earlier read petition? Para 10. Page 11, para 10, that being aggrieved and dissatisfied with such discriminatory treatment meted out of the petitions by the respondent authorities, the petitioners were compelled to approach this honorable court by way of a writ petition being 4838 of 2001. Inter alia, praying for a direction to the respondents to confer the benefit of regular scale of pay to the petitioners as per rule and pay their arrear salaries. The honorable court, after hearing the parties by an order dated 6/12/2001 in the interim, directed the respondents to make payment to the petitioners. That in pursuant to the interim order passed by the aforesaid, petitioners continue to receive fixed pay of 2,500 and subsequently thereof during pendency of the petitions were assured by the respondent authority to make payment to the petitioners their arrear and current salaries as indicated in the advertisement in question in condition of withdrawing the petition filed before this honorable court seeking payment of their salaries current as well as arrear. The file was also processed and as such the petitioner withdrew the petition being WPC 4838 of 2001 on 10/8/2007. That order of 10/8/2007 is not on record. If it is a withdrawal simpliciter, then this petition will not stand. It has the same prayers. And in fact, my lord, he will have to have a conference with his clients. My instructions are that from 2021, they are being given the regular scale of pay on the condition that they will give up claim of all arrear salaries or all arrear. Pursuant to the cabinet decision. That may be a copy. So perhaps you need to confirm that also. Revival of the repetition may not help.
Yes, Mr. Sharma,
Yes,
then your
I have-
argument would be
I have-
counterproductive.
I have individual copies of the orders.
My lord, here,
Individual orders of
lordship
regular
has.
pay, which has been granted since 2021.
Would you, yes, yes. And here, my lord, at the second page, the notification. In pursuance of cabinet decision in the meeting held on 20/2/2021, the government of Assam is pleased to notify and allow the benefits of regular time scale of pay as per ROP rules to following 77 graduate teachers who were appointed on fixed pay during 2001 and now working in different provincialized high school, higher secondary schools of Lakhimpur district by arriving at their pay notionally with effect from the date of their joining as shown against their name or from any other subsequent date, whichever is later. The payment of enhanced salary shall be made from the date of issue of this notification and no arrear salary shall be admissible for the past service prior to issue of this notification. Serial number 13 is one review petition repetition. Then, my lord, we have serial number 40, 44 and 65.
Just open 13, serial number
13.
13.
Parul Datta.
His petition number 1.
My lord is. No, his petition number 2, if I'm not wrong.
Petition number 2, yes. Next.
Then we have serial number. His petition number 3 is Parul Datta. Here serial number 13. Then Pradeep Gogoi at serial number 40. Petitioner number 1.
His petitioner number 1. Okay.
Serial number 45.
Yes.
Leela Gogoi.
Oh, I am 130. I lost my time. There's a meeting was passed. Huh, 20. Okay. You want your name to be recorded?
My lord.
Mr. A. Burma. Okay.
I'm obliged, my lord.
Yes.
45.
Did you take instructions? Because then it will be counterproductive to what you are arguing. If they have accepted the posts, so they are bound by this.
In fact, if I just submit one small submission in this regard, Your Lordship, subject to what your lordship deems fit. The submission that my learned friend has made based on the policy that has been meted out. That will be a subject matter of WPC which I cannot dispute now. That will be a subject matter of WPC to contend with the submissions of the review petitioners in WPC. My submission is, Your Lordship, this review petition is a very narrow campus. Is that whether the review be remanded back or not? What happens with the single judge, for the honorable single judge? That is subject to a different conversation. That is my humble submission. If your lordship is satisfied that the entire review order was based on a certain premise which was not applicable to us, as I've shown your lordship. Thereafter, what happens for the honorable single judge, if my petition is allowed or subject to any mission that lordship deems fit, that cannot be in my humble submission, be my submission before this court now in this review petition. All of these grounds.
No, you see, there are two
Yes.
ways of looking at it.
Yes.
Number one, first is that we take the review petition as is envisaged under CPC
Yes.
to send it back
Yes.
and to have the writ petition revived.
Yes.
The second option is which is normally follow, that the review petition, we pass an order and the order in the main petition stands modified to that extent. So why two sets of hearing for a same cause? In the review petition, we'll be arguing exactly the same things which will argue in the writ petition. So why hear the matter twice?
In fact,
So the 2 points which have come out,
yes.
number one, is that you will either proceed on the premise
Yes.
that the previous two writ petitions, whatever orders were passed
Yes.
in the two writ petitions, is the basis of your review petition, number one. Second is the view which I have already told you,
Yes.
the manner in which the matters proceeded, coupled with the fact that the earlier writ petition after the interim order was withdrawn.
Was withdrawn.
And the second part is what Mr. Mazumdar is saying, that you have already got a appointment order with effect from 2021,
Yes.
which says that you will not take the benefit of the past
Yes.
services. In any case, if that is accepted, then there's no merit, there will be no merit in the review petition. It will only be an academic exercise.
It will, in fact, what happens in lordship, the state being the employer that the state is, generally, the petitioners, your lordship, having not been accorded their pay for more than 20 years. There'll always be in a backhand, your lordship, to accept the terms and conditions of the state. Now the petitioners are fairly well.
No, you take a, Mr. Sharma, you take a risk and argue,
Yes. No.
because that the fact is that if with the view which I have tentatively expressed,
Yes.
it's not a final view which I am taking.
Yes.
It's only we are just discussing it loudly.
Yes.
But the fact is that if that view is otherwise found acceptable, then you also stand to lose whatever you are getting.
Yes.
The fact is that we'll deem it that your appointment itself will be under challenge, because you see, you can't have what do you call, the principle of appropriate and reprobate can't go together. You accept the appointment with whatever condition is attached to it. You question that the propriety of the conditions attached. So whether that is permissible, having accepted the appointment with that contract.
I'm in agreement with the lordship observation. Lordship, so you can grant the liberty to take instructions from the client.
You take instructions when you will keep it after this view vacations.
I'll leave it to your lordship to fix a date.
Because these days I am unable to take up.
Yes, absolutely, your lordship, I'll leave it to your lordship to fix a date convenient to your lordship.
Okay. Mm. Mr. M. Sharma, I'm counsel for the petitioner. So Mr. R. Mazumdar and the standing counsel for the Secondary Education Department has produced a copy of instructions dated 13/3/2023 from the Director of Secondary Education Assam, along with a copy of notification dated 26/2/2021. And it is submitted that the petitioners, along with several others, were appointed as graduate teachers
31/3, Your Worship.
with effect from
31/3, Your Worship.
31/3/2021.
Yes, no. 2001.
Like 2001.
Yes, sir.
No. Cabinet decision so and so is pleased to notify the allowed benefits regular time scale who were appointed in so and so. By 11 so and so over a subsequent date, whichever is later. Yes, Mr. Mazumdar, give effect from when?
The benefit now we are giving from the date of issue of the notification, 26 February 2021, the scale benefit. Otherwise, salary at the fixed pay, they were drawing from the date of their appointment.
They were given regular time scale with effect from the date of notification. So it is submitted that from the date of their initial appointment till the date of notification, dated 26/2/2021, the petitioners will be entitled to fixed pay salary.
But that period would be
And-
taken into account notionally.
And
Already
the
fixed
said
now.
period shall be considered notionally for other benefits, including pension. But the petitioners would not be entitled to their arrear salary from the dates of joining in their respective schools. Next, para the learned counsel for the petitioner. Grace Foreign is granted time to obtain instructions. List immediately after the ensuing view petitions.
Lordship has said, including for pension, matter, that is not recorded in the order. What I was saying is, we will take it into account notionally to fix their pay now.
That's it. Right, it will be taken into account notionally to fix their pay now.
Now.
Okay.
Grateful, Your Worship. Met with Your Lordship.
Yes,
430 application of the second bill application.
Mr. Goswami,
Lost. CD is there, my lord. And as per your lordship's last order, your lordship may kindly peruse regarding the involvement of the petitioner, my lord. He is the, my lord, one of the mastermind, my lord, in committing the such type of theft, my lord.
but here it is considered whatever has been stolen was recovered from someone.
Yes, my
Yes,
lord.
my lord,
Recovered
they,
by someone.
there are 4 persons, my lord. They all, my lord, distributed among themselves, my lord. So some are yet to be recovered, some it was. And my lord, some articles are along with this petitioner, my lord.
What has been said, my lord, regarding other cases, their witnesses are telling like this. Because in this case, my lord, we have no involvement. They have not found any involvement because we are only searching. It is already 10 months past after the incident. Yeah, he has got sufficient time to retrieve whatever he has recovered, and 2 persons mentioned in the affair. Both the persons are arrested. One lady and one boy. They are arrested. Recovery also made from each of them. So, my lord, we have nothing to say. After a long lapse of time, we may be allowed to.
Okay, just give the CDI because I forgot.
Yes, my lord, your lordship will see, lordship, I'll give the city, man. Page 14 is your lordship's last order.
Yes, I've seen
Yes,
that.
yes, and my lord, regarding his involvement, my lord, their statements of the other arrested accused, my lord, how much per amount he got from that incident, my lord. I have got blackboard, my lord.
This is something I've forgotten.
Yes, my lord.
I'll see and pass orders.
Yes, my lord.
Lordship.
Other, my lord, I am willing to surrender before the learned court of Sijam. That observation may be recorded, my lord.
Okay.
May it please your lordship, third bail application. As of now, 451 days behind the bar, your lordship. And only 7 PW have been completed yet, lordship. So considering the length of detention and considering the preparation of defense, the accused petitioner will be released on bail, lordship.
Where is the FIR?
Lordship, FI is a page 13, your lordship.
13.
First.
All are eyewitnesses to the incident, man. So far, my lord, LCI is concerned.
I just wanted to see the postmortem report of the.
Yes, my postmortem report, my lord. The report is not there, but there is a nothing is there, my lord. The death is due to result of head injury, my lord. I have flag marked one portion in the my lord CD, my lord, in the second last paragraph flag, my lord. And it also contains the my lord dying declaration of the
Dying declaration I have noted.
yes, my lord. Along with that, my lord, there is a nothing that
Cause of death. Okay,
Cause of
it is
death.
there. It
Yes,
is
ma'am.
due to coma resulting from head injuries. Antemortem and so and so.
yes. Some of witnesses are relative and some are independent witnesses also, my lord.
But Mr. Bodley, in light of section 436 capital A, what do you have to say? CRPC. Four 36 entitles you to bail. Only half the sentence has been
Lordship,
undergone,
Lordship.
and that is again bolstered with the judgment of Satyendra Singh until.
Lordship. But Lordship, on last occasion, also Lordship 7 PWS has been completed, Lordship. Now also 7 PWS has been completed. On last occasion, 230 days, 36 days, now 451 days, Lordship. So for preparation of his defense, Lordship, any strict condition that may be imposed upon him, Lordship.
Okay, let me go through it and pass on.
Some are the, my lord, two are the perhaps the vital witnesses and one IO is there and another two witnesses are vital witnesses are there, my lord.
No, Mr. Bodle is saying that earlier when the bail was moved,
Yes, my lord.
it was 236 days.
Lordship,
Now he has moved after 200 days.
Lordship.
Yes, it was earlier order is my 25/8. It is in the month of August.
So
As per my information, Lordship, I has not been examined yet, Lordship.
no, IO will come late, last, after the
IO
other
will come.
witnesses are over. I can't direct the IO to be taken up first.
Two witnesses.
Unless you give an undertaking that you will forego the, what you call, the benefit of contradiction with other witnesses. If you forego, then you can give a direction. Otherwise, IO is only for contradiction.
Yes.
Any strict condition, Lordship.
I'll examine, but chances are less.
I'm deeply obliged.
There was some instruction I wanted at 2 o'clock.
Regarding that item number 3. There was an item number 3, my lord, on which lordship had fixed it to.
4.
Item
Yeah, 4. Item 4.
4 perhaps. WPC 5401 of 16.
5 is item number 4.
4, I'm sorry, my lord.
Yes,
My
sir.
mistake. My lord, I have asked for an instruction. But, we had to get it from the school, my lord. Because the repetition itself says that the person concerned who was appointed, she was terminated on our instructions. Now the second post, she wanted to take up the person as the second person on the merit list. That the Supreme Court has already held that it cannot be so. Once the person from the select list is appointed, the select list exhausts. Nothing remains of the merit list. And I had tried to contact Mr. Nair also. Perhaps the petitioners are not in contact with him also.
Okay, take it up on Friday, then get the information by then.
Should come.
On the prayer made by Sar Mazumdar and Council for the Secondary Education Department. Matter since adjourned today to enable him to obtain instructions. List on with Friday 31. Yes.
As in this case, we have challenged the impugned suspension order of the petitioner, my lord, who has been issued in 7/3/2017. Is at page 48, my lord. But what had happened in this case, my lord, the
This
petitioner-
suspension must go, but that inquiry should go on because
Yes.
this
Yes.
1 year PhD in 1 year is something it's not acceptable.
But yes. Lordship, let them start, Lordship, as a case.
Huh?
Lordship, K. Gogoi will submit, Lordship, in this matter, Lordship.
Okay.
Let them start, Lordship.
No, let him come because I'll not adjourn it once I start hearing.
Yes, my lord.
Let Mr. Gogoi be here. Yes.
My lord, opposite party. I was asked that the respondent has said that it should become infractious. But I
Because
have
two thousand 17 Act will now come. And there is a judgment of this court which says that 2017, it will be considered under the 2017 Act is by a division bench of this court.
No, here is the case, my lord. It was done in 2011, my lord. Your lordship kindly have a
No,
look.
but that act is set aside.
That act is set aside, but what
And
is
therefore,
only-
therefore the provincialization can't be done under the old act. So you must fit in the criteria of the new act. So you have to, matters to be delegated to the authorities to examine your case in light of 2017 Act.
the post is already, I think, post is already provincialized, I think, but I could not
No, I
contact.
understand,
the
but
client.
you see, your fitment has to be under the 2017 Act if you meet the parameters. So the authorities will have to take a decision on the matter.
But whether the 2017 Act will apply in case of retrospectively, because this is.
No, it will be considered
It is
prospectively.
prospectively, and if that be so, the director has already passed order regarding the matter that is phase 46, my lord. That is 46. So director has passed the order on 24/6/2016. So here I see, my lord, there is no whisper regarding the under which act this order has been passed.
No, in 2016, the 17 Act was not there.
Yes.
17 Act has come later on.
Then, my lord, my submission is this: when this order was passed, at that time 17 Act did not come into existence. Now, whether which was continuing case, whether that would be covered by that this 2017 Act, on this point, my lord, I think the other day, I think many orders have been passed when this 2011 Act was passed. Even then, several orders have been passed that which have been already done, that cannot be made undone. I will satisfy on your on this point, your lordship. Kindly fix the matter after 1 week. I will satisfy.
No, it goes after BO vacation. Because these days I will not be able to hear the matter.
In
Yeah,
the meantime, may I suggest my learned friend, my lord, may take instruction whether his client has been provincialized under 17 Act, my lord. My lord, uncertain instruction is that, my lord, he has been appointed
Consider-
as tutor, my lord.
He's been appointed as tutor.
My lord, uncertain, my lord,
No,
therefore,
it's
he
okay,
may
it's
take my
okay.
lord instruction. my lord.
Okay.
And my lord, the 17 Act has come 11 April 2017, my lord.
Yeah, I'm aware of it. Mr. M.U. Mahmood, learned counsel for the petitioner. Mr. U. Sharma, learned standing counsel for the Secondary Education Department. And Mr. A.M. Bormaya, learned counsel for the private respondent. Next, on the prayer made by learned counsel for the petitioner, the matter stands adjourned to enable him to obtain instructions. Next, Mr. The learned counsel for the private respondent has submitted that as per further information received by him, the service of the petitioner has been provincialized as a tutor, as he was untrained teacher.
Yes, sir. He may very well.
Said statement may be verified by the learned counsel for the petitioner. This is the matter immediately after the ensuing BO vacations.
All right. Actually, I have also not got any information.
Pardon me?
I have also not got any information regarding the present status. I will
No,
take.
because there were exercises carried out by the state government. And many people have been adjusted who are trained, they are teachers,
Yes.
who are untrained, they are tutors.
Yes. Maybe, but I have no information.
Take instruction.
I will take
am not
instruction.
sure. I am telling.
If that
frankly.
be so, then my case would be infractious. Obliged.
No problem.
That is the benefit of having a caveator. That is the benefit of having a creator.
Once the service is, I think, provincialized, he has forgotten his lawyer. That is the problem.
No, no. They will not forget unless you are reasonable.
RT6. Lordship, this case we have lost contact with our client, Lordship. And we have prayed for a review of the order dated 29/8/2019, passed in WBC 6168 of 2019.
Yes.
Lordship, it's an advertisement that was issued in 2019, Lordship, for filling up vacant posts of graduate and postgraduate teacher in provincialized secondary schools in Assam, Lordship. The petitioners were not in that case, Lordship. They were not TET qualified, Lordship, and their contention was that since TET was not being held since 2013, Lordship, they could not appear in TET, and as such, they could not apply in this advertisement for that selection, Lordship. And Lordship, there was an observation made in that order, Lordship, whereby I was agreed, Lordship, that we are seeking review, Lordship, at page 47, Lordship. Roman 3, Lordship.
But that is something you can't wish away.
Lordship.
This is an observation which has to be complied with.
Yes, Lordship. But then we qualified it in 2016, and because of this observation, Lordship, the process of the selection was stalled, Lordship. So we are agreed, Lordship.
But then this can't be corrected in review. You'll have to have a next cause of action, because you are trying to say that in terms of the observation in this what do you call this, para 3 of para 11, you have subsequently acquired that qualification.
We have acquired it in 2016, Lordship. And we are not party in that writ petition. We were not party in that writ petition, Lordship. And we being qualified, Lordship, we since the selection process was stalled, Lordship, we were agreed, Lordship, being not party in that writ petition.
Who is appearing for the private respondents?
Yes, there was a paper publication made pursuant to a direction of the Honorable Court. And
No, but there's that affidavit of municipal publication is not there. And first you'll have to take steps, and only then newspaper publication will come. Newspaper publication cannot be the first step.
Lordship, we had earlier taken steps, Lordship, but it was not effective.
Second file.
Earlier, Lordship, we have taken steps on 1/11/2019.
You have given advertisements. Yeah.
Lordship, I have been told that the selection process, filling up those posts is pending consideration of this honorable court in another case, Lordship.
Issue, not this issue. Based on these orders, our advertisements have been stopped. Representation. বসে মাসে অলোকে স্কুলটা 2020 মাসে
In 2020.
And I'll tell you, Mr. Sharma,
Lordship.
why you should read my book,
Lordship.
CPC. Show you that.
অলোকেশ স্পেলিং টো কি মানবি
Given your CPC, for the purpose of showing you order 3 rule 4.
Yes, Lord.
Appointment of pleader,
Lordship.
correct?
Yes, Lordship.
Now explanation, for the purpose of this rule, following shall be deemed to be proceeding in a suit,
Lordship.
correct?
Yes.
Now you'll find A, application for review. You've seen that?
Lordship.
Explanation A,
Lordship. Of decree or order in a.
Correct.
Yes, Lordship.
so therefore, for a purpose of review, the same lawyer appointment continues. Now come to this rule, High Court rules. Nine,
Lordship. In civil cases, the appointment of an advocate unless otherwise limited shall be deemed to be enforced to the extent provided limited in that behalf by rule for order 3 of the Code of Civil.
Correct.
Procedure. Lordship.
so 4 years back, you could have served it on Mr. Nayak and it would have been a good service. Now with passage of 4 years, your affidavit of taking the steps by newspaper publication is not there. Now you'll have to take steps once you have foregone that. That is why this is something you must always.
In fact, my lord, we had published advertisements for postgraduate and graduate teachers. Relying on this judgment, those advertisements have now been kept on hold.
Evidence.
That was recently around a month ago.
Because of this order, this
Because
judgment.
of this order, we were asked not to make any advertisement without doing, without conducting the TET. We have not conducted the TET. So on that ground, it was still.
No, but if you don't conduct a case, that will be what they call.
It is being, it is getting it done.
No, not even that. You are doing contrary to the act
Yes, no, the.
every year.
Yes, because matter
The NCT guidelines says it every year.
that NCT guidelines only is for the primary schools.
No, it doesn't distinguish.
It
The-
does,
the
matter.
TET
The NCT guidelines itself says that TET is mandatory for LP schools. It is not mandatory for the secondary classes. Beyond 8, it is not essential. It is what we have brought in into our 2003 rules when we brought it in. Then we brought it in 2000, this TET. In 2018 rules, I'm sorry.
You take steps.
Lordship, but we have lost contact with the clients, Lordship. I don't know how.
But that is
try-
something that is something that we will not be able to accept it because you
No.
see.
I'll try, Lordship. Lordship may give one opportunity.
uh, Mr. M. P. Sharma, Learned Counsel for the petitioner, submits that he has lost contact with the petitioners, with the review petitioners. He prays for some more time to serve notice on the private respondents through substituted service by publishing notice in the newspapers. Next paragraph. The have you noted that this review petition is pending for service of notice on the respondents? From the plea of the plea taken by the learned counsel for the petitioner would not be acceptable. Because even for default, in taking steps for service of notice on the respondents, the review petition may be liable to be dismissed. Next paragraph, be that as it may. As a last opportunity, the matter is adjourned today. List after ensuing leave vacation. By this time, we take appropriate instructions. Yes, appropriate orders will be passed on the next day for issuance of notice by in a substituted manner.
I just pointed one thing, another review petition regarding the same judgment. It's review petition number 2 of 2021. That is also pending now. It is not tagged along with, but I've just had a check with the records.
On the next date, you make a because this is for service.
Yes,
On the next date, you make a submission. Will add it. Just make a note somewhere. No, this case is not for service, not ready for service. So I would not tag the matters right now.
That is just for that we have found the records.
Then
Another review.
both the cases would not proceed. Then
Published.
number 10.
Lordship, I apologize, Lordship, in another matter is going on, Lordship. I apologize.
Is that inquiry can be made, but he can't be kept in suspension for so long.
Lordship,
You can continue with the inquiry, but you can't suspend it for so long.
Lordships. Malad, me hear the matter as a whole, Lordship. On what reasons, what ground we have to do this? Lordship?
Your ground is only one, that
Lord-
his degree, you are questioning the degree.
Lordship, Lordship,
Correct.
Lordship.
So that you may go and prosecute him for whatever he has done, but why the suspension would be continued? Suspension, continued suspension is against Ajay Chaudhary.
Lordship, earlier occasions of petitioner approached before this court, Lordship. Although so this principles is that, Lordship, within that period, Lordship, we are not submitting the charge sheet, Lordship. Lordship, we have submitted charge sheet, he has replied, Lordship, the departmental proceeding is going on in the final stage. So due to the pendency of the court case, we are not able to take a final decision, Lordship.
Has anybody stopped you? No.
That part is not there, Lordship.
Then it
That
is
part
your
is
own,
not there,
it is your own choice not to proceed.
Lordship.
Because unless you can demonstrate
Lordship.
that you have a right to continue his suspension, just because you chose not to proceed with the with declaring the final outcome.
Even Lordship, earlier occasion petitioner approached before this court, Lordship, that was not interfered with also, Lordship.
No, but now with Ajay Chaudhary, we are bound to interfere now.
There is no extension also.
You are referring to 3477 of 2017,
Lordship.
right? But there was a direction to dispose of his representation.
His representation dispose of, Lordship.
67, my lord.
His representation
67, page
dispose of, Lordship.
67 is the disposal.
Dispose of.
My lord will see that. There is no extension of the order of suspension 1. And 2, my lord will see why it was rejected. My lord, the above paragraph just denotes the facts. The last The third paragraph
No,
from bottom,
Mr. Nair,
Lordship,
this is only technical view we are taking,
Lordship.
but on facts, we may not have sympathy with you.
Need not have, my lord will not have any sympathy. My lord will only see whether I can be kept under suspension. One, my lord.
After that,
No, my lord. If my PhD degree is holding the field, Magad University has said that this is proper. As per our regulations, this has been done. You will have to cancel that degree, my lord.
no. The acceptance of the degree by the state can itself be.
My lord, then
Done.
the state must say we are not accepting any degree of Magad
No,
College.
that also is not required. I'll tell you
Because,
why.
my lord, why I'm saying so, in the state, there are more than nearly 100 persons who have done this. They're from Magad and they are continuing in their
You
service.
have the statute of Magad University.
Yes, it's been
Look at
annexed.
section 3, what does it say?
My lord would come to the
Just read section 3, what does it say?
section 70, madam, page 70.
Just read section 3, what does it say?
Section 3 of the,
Magad University Act.
my lord will see. My lord wants the annexure 22, my lord, page 70.
70.
That's the registration of PhD, DB.
No, not this. University statute, the act.
Oh, that
Which,
I'm personally not having now, my lord. I can have it, my lord, before your lordship. I have the PhD registration.
No, you
regulations.
see, there's a different reason altogether.
Lordship, maybe.
The reason is that under the UGC guidelines, the university can't give a PhD in what you call off-campus mode.
It's not given up. I'm not an off-campus candidate, my lord. I'm a registered candidate. I did my PhD from there only, my lord.
You took a leave?
Yes, the leave was granted by the college, my lord, at that point of time. And thereafter I went there, they gave me a registration. And then, my lord, I did the guide was there. And lordship would come to page 76, my lord. I think that will clear the issue.
But under the UGC guideline, it's a 4-year program.
My lord, maybe they gave me this extension. They gave me they have
But
this
under
scheme.
the UGC guidelines, what is the PhD, what you call guidelines?
Lordship, my lord will come to page
2009
76.
UGC the guidelines, Lordship. 2009 UGC's guideline, Lordship.
You have a copy of that?
Lordship, I have, Lordship.
My lord will have page 76, my lord. And UGC has filed an affidavit here, my lord. It will not go to no? There was a connected matter, my lord, wherein, my lord, the UGC had filed an affidavit, and therein they have said, they have categorically stated, my lord,
admission degree by
2009
my lord would, my lord, before my lord proceeds further, my lord will have that page 67, my lord. Disposal of my representation, Ajay Chaudhary,
I'll tell you to, you just see,
lordship.
now, you come to page 106.
It's the affidavit, I suppose.
Yes.
Yes, your lordship.
106 last 3 lines is coursework. Correct?
My lord will give me the internal page, my lord.
7.
7, sorry, my lord. Lordship.
Correct.
Mm.
Now this says coursework.
Mm.
Correct.
Mm.
Now you omit other part, and then you come to page 8, internal page 8,
Lordship.
last part again.
Mm.
Here it says he was awarded PhD by Magad University on so and so. It is admitted that he did not do coursework
Lordship.
as he was exempted.
Lordship.
Right.
Lordship. Lordship.
Then next line it says,
Mm.
there is no such provision or exempted coursework for serving teachers in universities and colleges.
Mm.
Therefore, the UGC never relaxed the PhD guidelines for that. And you know why I am so certain about this? Why out of all this, I only read this?
Lordship.
Because I was also an aspirant to have myself enrolled in PhD program.
Here, Magat, no, here.
No, here only. Not in Nagar. And then I was informed that this coursework
We'll have
is a
to-
mandatory requirement. I have
After
to do it.
2009. yeah.
And therefore I don't get a leave.
6 months.
My lord will, that my lord
And
is
that will,
holding
that
that.
will also make you understand
Lordship.
why our appointments are called warrant of appointment. So therefore, unless permitted, even leave we don't get.
Lordship. My lord, here what has happened here, there is a notification of at page 32, my lord. Sorry, in my reply that I have brought it on record of the UGC.
Replied.
Reply, my lord. It's internal page 32, my lord.
Because you see, the university statute cannot be contrary to the PhD guidelines because that minimum standards
Lordship.
are governed by that
Lordship.
2009 regulation.
My lord, I'm for a second, I'll not dispute. My lord, the coursework that they say, my lord, the UGC, the coursework, the UGC guidelines itself says, if found necessary, coursework may be carried out by so and so in sister departments, institutes, be that as it may. But my lord, here, the institute had itself, my lord, said that this is exempted for the category of people like us that for a particular period of time after that regulation had come in. And till date, my lord, the UGC has not proceeded against them in any manner.
No, you see, proceedings against that is different. But there is a Supreme Court judgment which Mr. Gogoi will point out. It says that the UGC guidelines have paramount effect.
My
Therefore,
lord,
it will overrule the status.
there was a doubt till the other day as to whether, my lord, the UGC guidelines are binding or, my lord, directory, mandatory or directory.
Mandatory.
In some cases, my lord, it was said.
Even the what do you call it is mandatory except for
Is
the
the state adopted, it is mandatory lordship.
My lord,
Otherwise, in the case of
no, no,
university lordship,
I'll-
Annamala
let
University
me
case, honorable apex
clarify.
court
Just
laid
make
down
that
the law
submission
lordship.
before court number 1 the other day, my lord. Once it was earlier said, once the state adopts it, then it becomes mandatory. Now, my lord, the latest decision from 2022, I forgot the citation, my lord, from Gujarat, VCS selection, it said, no, whether you have amended your statute or not, the UGC guidelines will hold it. So this is the law, my lord, there is no dispute. But my lord, before,
Regarding that,
by
lordship,
proceeding
if-
into that,
if
my lord,
lordship-
let him complete.
I
Let him
can
complete his
clarify
thought.
lordship regarding UGC's latest apex court judgment. That is come from state of Gujarat lordship, Professor state of Kerala Srishnath case lordship. It is clarified that
Let him complete. Let
Yes,
him complete his
lordship,
thought.
lordship,
Let him
I will
complete his
clarify
thought.
everything.
my lord, here, the order of suspension, my lord, is of 7/3/2017. I come up before your lordship, asking that this order be set aside. My lord was pleased not to set aside, directed for disposal of my representation.
Just a moment, Mr. Nair.
Lordship,
Two things. Number one,
lordship,
on merit,
lordship.
I really have doubt on the.
My lord, for
the
merit,
entire
they
degree.
have instituted a proceeding against me.
So therefore, the second part is that only so far as if we restrict ourselves only to the issue of suspension,
Suspension, my lord.
then we
I'm
don't
not
go
on
into.
the show cause, my lord. I'm not even challenging the show cause. I want them to proceed further. And they have not done nothing in that matter. Till now. I'm
Just-
only on the suspension.
Regarding lordship, whether the Magadha University can lordship violate the UGC regulation or not lordship.
No, that we won't go into.
Lord, it is clarified by the Honorable Affairs Court in Annamala University's case, Lordship. My lord, may kindly peruse for a moment the UGC's regulation 2009, Lordship.
No, then we don't have to go into that.
Lordship.
If the challenge is the
Only suspension order here.
simpliciter, then we do not deal with these issues.
And these issues are basically the issues that the department proceeding is
No,
looking.
just a moment.
Page 48. man.
No, just a moment. Let him complete his part. Because if that is so, then if the only suspension simpliciter is being challenged, then we do not answer those questions. It will depend on your inquiry, whatever way you want to do it.
They'll page 26 is my prayer, madam.
Because then if we answer this, there's nothing remains in your inquiry.
Lordship.
So we omit that part.
Lordship.
So far as the inquiry is concerned, you are proceeding, you can proceed. But so far as suspension is concerned, once there is no extension,
Lordship.
that is a well settled law.
That, Lordship, we have not any dispute regarding there is no extension parties there, Lordship. Otherwise, Lordship, regarding the degree, Lordship, whether the Magadha University can relax the UGC's required qualification or not, Lordship. My lord, may kindly peruse the 2009 regulations under
No,
which
Mr.
provisions,
Mr. Govey,
Lordship,
you are not trying to understand.
Lordship,
You see, we are hearing the petition of Mr. Nair,
Lordship,
right?
Lordship,
I can't make an observation which is contrary to his prayer.
Lordship.
In the writ code, there is no concept like cross
If
counterclaim.
Lordship, if it is pair is limited to the only the Lordship, what Lordships has already said, Lordship. Then Lordship may observe that the departmental proceeding is as part.
My lord.
Yes.
It's he who brought these things up.
I am not bought in these things. You have bought these things by
It's
way
okay,
of.
no personal agreement,
Way of
please.
reply. I am not.
No,
bought these
no
things.
personal replies. This is not a place.
My
where
lord,
you
That-
can have-
that Lordship,
bought
I bought these
suspension.
things, Lordship. It is not a case that I bought this thing. It is our duty to
No,
point
it's
out
okay,
before
but
the
no,
honorable
no,
court,
no
what
personal,
is the law, Lordship.
no personal
lord,
exchanges.
Page
Petitioner
26
has
is my
annexed a
prayer.
document, Lordship. Petitioner has,
Away,
Lordship,
this is something I won't desire.
Lordship, Lordship.
Correct.
Page 26 is my
Personal
prayer. my lord.
agreement in the
Lordship.
court matters. You
Lordship.
two can't have a spat
Lordship.
at my cost.
Lordship.
Correct. I am a person who likes to smile and laugh and then
Lordship,
pass
Lordship.
my day.
Lordship, Lordship.
Correct.
Lordship, we are replying, Lordship, on the basis of the
No, it's
documents which
okay.
is annexed in the
But
petition,
no
Lordship.
personal replies.
Nothing else, Lordship.
No
My
personal
lord,
replies.
page 26 is my prayer.
We have bought these
I have
things on the basis
challenged-
of the document annexed in the writ petition, Lordship.
I have
okay.
challenged page 48, suspension order. As well as, my lord, the rejection order in persons to this honorable court's directions, which my lord would find
Page 67, I've seen that.
67, my lord. And herein I'll have my lord's attention, the last three paragraphs, as well as the paragraph thereafter. There is no extension.
No, there's no need to do anything with
No,
this. The
extension.
final orders which are passed will govern it.
Okay.
We just don't
And
don't say
the
about it.
department proceeding, it's not under challenge, Your Lordship. That will proceed in accordance with law.
Heard. Mr. You can add, let's say, council.
Mr. R. Islam.
Assisted by Mr. R. Islam, and counsel for the petitioner. Also heard Mr. K. Govey, Lamed, standing counsel for the Higher Education Department, representing respondent numbers
1, 2, and 3, Lordship.
1, 2, and 3. And Mr. A. Shamwa, Lamed, standing counsel for UGC, appearing for respondent number 4. Next paragraph. The case of the petitioner is that he was placed under suspension by order dated 7/3/2017 by the who was suspended him,
Madam Director.
the Director of Higher Education Assam. Within bracket respond number 2.
48 and 49.
And accordingly, agreed by the continued suspension, the petitioner had approached this court by filing WPC 3455 of 2017 And this court, by order dated
9/6/2007.
9/6/2017, disposed of the writ petition by directing the respondent number 2
Director.
to dispose of the representation dated 21/4/2017 of the petitioner for withdrawal of his suspension order. Next para. On 3/6/2017, from a show cause notice was issued to the petitioner along with statement of allegations, etc. It was served on him on, which is claimed to be served on him on 21/6/2017. And by separate order dated 3/6/2017, the then Deputy Director of Higher Education was appointed as inquiry officer. So it is claimed that till the date of filing of the writ petition, neither any inquiry was conducted, nor any departmental proceeding has taken place. First of all, it is also submitted that it is submitted by the learned counsel to the petitioner that in the meantime, the petitioner had submitted a show cause reply dated 19/7/2017. Next one. In the meanwhile, the Director of Higher Education, Assam, had passed an order dated 2/1/2018, thereby rejecting the representation dated 21/4/2017 of the petitioner. Next. In brief, the background fact is that the service of 3 lecturers were terminated, against which those lecturers had filed WPC 2479 of 2015 and took a plea that the PhD degree obtained by the petitioner is not in conformity with the UGC regulations. During the pendency of the said writ petition, a show cause notice dated 30/12/2016 was issued to the petitioner, against which reply dated 11/1/2017 was submitted. And it is also projected that in connection with WPC 7174 of 2013, the respondent number 2 took a stand favorable to the petitioner. However, the point relating to the sustainability of the PhD degree obtained by the petitioner has not been gone into, as it is the subject matter of the proceedings initiated by the respondent number 2 against the petitioner. Next paragraph. Hence, the court is only visiting the issue arising out of continued suspension of the petitioner from 7/3/2017 till date. Next paragraph. The learned study council for the respondent numbers 1 and 2 has referred to this time taken by the taken in the affidavit in opposition filed by respondent number 2. And it is submitted that public petition of public petition containing 80 signatures was received with the allegations questioning the PhD degree of the petitioner, for which inquiry has been instituted. First of all, accordingly, it is submitted that as there is bona fide doubt with regard to the genuineness of the PhD, the genuineness and sustainability of the PhD degree obtained by the petitioner, or the inquiry was proceeded with, however, during the pendency of this writ petition, no final decision was taken by the authorities.
In my lord, paragraph 22 lordship, already expert committee has viewed paragraph 22 lordship. In our affidavit lordship. Paragraph 22 lordship.
First of all, it is submitted by referring to statement made in paragraph 22 of the affidavit in opposition that an expert committee has already dealt with the PhD degree obtained from Maharaj University.
Lordship, paragraph 22, it is.
I have said that because this is something I am not going into.
Lordship.
Next one. The learned study council for the UGC has referred to the various notifications and guidelines issued by the University Grants Commission in the matter of conferment of PhD degree by the universities next paragraph. As indicated earlier, the issue relating to the genuineness or sustainability of the PhD degree obtained by the petitioner has not been gone into, as the same is subject matter of the departmental proceeding against the petitioner. Next paragraph. On a pointed query of the court, the learned study council for the respondent numbers 1 and 2 has submitted that he has not been instructed as to whether the order of suspension against the petitioner has been extended from time to time in accordance with the departmental proceeding norms. Full stop. Under such circumstances, the court finds that the ratio of the case of Ajay Kumar Chaudhary, what is that citation?
2015 7 SSC, page 21.
No, what is the citation? Ajay Kumar Chaudhary versus?
Ajay Kumar Chaudhary versus Union of India and Union of India through the secretary and another.
Union of India and others, and another. 2015
7 SSC 291. Relevant para 21.
It has been laid down that continued suspension of the employee without
my lord, review and extension of this.
Without review and extension will not be sustainable.
After 3 months.
After 3 months.
Or, my lord, on issuance of the show cause notice.
Or on issuance of show cause notice. Next paragraph. With that. So in view of this decision rendered by the Supreme Court of India in the case of Ajay Kumar Chaudhary within bracket Supra, coupled with the fact that as on date, the order of suspension of the petition has not been reviewed or extended. The court finds that the continued suspension of the petitioner would not be sustainable. And therefore, the order of suspension, impugned order of suspension, bearing number, page 48. Bearing number so and so, dated 7/9/2017.
7-3.
Is prospectively held to have spent its force. And therefore, the Director of Higher Education Assam within bracket respond but 2 shall now pass appropriate orders to restore the petitioner to his position. Next paragraph. In this writ petition, the petitioner has also assailed the order dated 2/1/2018 as by the respondent number 2. So, in view of the prospective interference with the order dated 7/3/2017. No fresh order is required to be passed in respect of the impugned order dated 2/1/2018. Number is page 67. PHC so and so and so on. And they said order also is deemed to have lost its force. He should be restored in his position. I said it will be he'll be reinstated into in service. A consequential financial benefit to which you be found entitled to. Next paragraph. This order shall not be a bar for the respondent authorities, especially the respondent number 2, to proceed and conclude with the departmental proceeding and initiative against the petitioner. Which is pending since the year 2000, since 2017. It is expected that the respondent number 3 would bring the same to its logical conclusion, preferably within a period of
1 month, Lordship. 1 month,
you'll be able to do it.
Lordship. Already, Lordship. Everything is over, Lordship. Due to
But in
pendency
outer
of this
period,
case.
within the outer period, preferably in the outer period of 2 months from the
Lordship,
date of receipt of a certified copy of this order.
Lordship.
And my lord has interfered with the order, so today I am in, my lord, but there is to be a consequential order. My lord will direct them to pass that within a period of 7 days from the receipt of the copy. Otherwise, I am in, my lord.
No, I already said that he will.
Or some
he will
time
instate-
frame, Malad, they will keep it pending.
No,
then
no,
he
I
can-
already said that he'll file constitutional order to instate you. Yes, I have already said.
But that, if there is a time frame not given, Malad, they'll not do it, they'll keep it, Malad. So
No,
Malad
no,
will
they'll
say
do
7 days. Because Malad,
Uh,
Malad's order
Constitution-
interference, I mean.
Constitution. The instate for his constitutional orders shall be passed within a period of
7 days.
7 days.
7 days, from the date of.
15
receipt.
days, within a period of 15 days.
Okay, make it 15 days.
15 days, no problem. Much better.
That's
We'll
fine.
complete in 1 month, Losi, and he will get 15 days, Losi. Because observation is also there, Losi. Oblige, Losi.
This book is by you.
Losi, Losi.
So that the last day you gave me a comparison, you gave it, na?
Losi, I have
Okay,
received, Losi.
okay.
Much better.
Oblige, Losi.
Just remember and take it because otherwise everything becomes confiscated.
Losi, oblige.
I would forget after some time.
I already. Oblige, Losi.
No, this is not required. No, no, this is not.
37.
Wait,
Yes.
contempt petition order dated 10/4/2018. Now, Lordship, Lordship, at page 9, they have to pay the back wages.
Yes,
Yes, my lord, I have received some instruction.
what?
Matter is under process, my lord, so some time may be allowed, my lord. Now he is receiving the regular wages, my lord. And for the back wages, we need some time, my lord. Already we have sent a proposal. Yes,
Give them time, sir.
yes.
Mr. B.P. Boran and counsel for the petitioner is present. This name I always forget your name.
My lord,
Your name I always forget.
and Fukan, my lord.
Mr. N. Fukan, then the
Respondent
standing counsel for
number
the the counsel for respond number 3. 3 or 2?
2, my lord.
2. Has produced a copy of instructions. And it is submitted that the petitioner has started receiving the current salary. And for the back wages, they need some time to process the proposal.
Lordship may also add page 11, because at page 11, they have done some work at page 11, Lordship would
So
see.
for the time being, I'm not saying anything.
Yes.
I'm just taking note of a submission. I'm adjourning the
Yes,
matter.
yes,
Accordingly, the court is inclined to adjourn the matter. The direction to the respondent number 2 to produce the updated instructions on the next date. How much time you need, Ms. Fukan?
2 weeks.
2 weeks. Okay. This is the matter on 21/4/2023. Therefore, the learned counsel for respondent number 2 shall send a downloaded copy of this order to the respondent number 2. So it's unable to obtain instructions. The instructions produced by the learned standing counsel, the learned counsel for respondent 2 is retained on record.
38.
Yes,
It's content application, my lord. You will find the order dated 11/4/18, my lord, page 8,
Thank you.
11%, page 10, paragraph 5.
Paisiba. আমি দেখোন চেঞ্চন লিখছো নহয়
what did you say?
We have already sent some amount, my lord.
How much is your dues?
My lord, 4,11,500.
Then it is sanctioned.
Yes, madam.
Then it is sanctioned.
That only, my lord, as per
We'll keep it pending. I'm not closing it. Let them, get it benefit. Mr. R. Sharma, and counsel for the petitioner is present. Speak, counsel for respondent number
Respondent number 3.
3 has produced a copy of letter under number capital E 2430 46 / 237 dated 17/3/2023, by which sanction for a sum of rupees 4,11,555 for payment of annual salary to the petitioner has been sanctioned. And the communication to that effect has been made to the Accountant General Assam. Next, accordingly, matters stands adjourned today to enable the
Sorry, my lord, I'm appearing on behalf of respondent 1, my lord.
respondent 1. Okay. Matters stands adjourned today to enable the respondent number 1 to provide further instructions as to whether this copy is also sent to you.
As per my instruction, my lord, the sanction order has already been sent back to the Treasury Office, New Silchar, my lord. But as per my instruction, the Treasury has some instruction from the Finance Department not to release any amount after, my lord, 18. So the letter has received on, my lord, it was, I think, issued on 17/3, my lord. So after 18, my lord, they have not released any amount. That is the present status, my lord.
The learned counsel for the petitioner submits that the sanction has been received by the concerned Silchar Treasury,
New Silchar.
new Silchar Treasury, but as per his instructions, the Finance Department has issued an instructions to the said Treasury not to release any funds after 18/3/2023. So hence it is submitted that till date the petitioner has not received his arrears salary. Next one. Accordingly, the respondent number 1 may raise the matter about non-payment of the sanction amount to the petitioner with the Finance Department. Full stop. If by the next date of listing, the issue is not resolved, or the respondent number 1 shall inform the names of the persons in the Finance Department where the matter related to release of area salary of the petitioner, sanctioned area salary of the petitioner has been withheld. Next, for the learned counsel for respondent number 1 shall transmit a downloaded copy of this order to the respondent number 1. To bring the notice, the order to the notice of the said respondent. Next, a copy of instructions produced by the learned counsel for respondent number 1 is retained on record. List on 26/4/2023. The pendency of this contemplation shall not be barred for the authorities to release the payment due to the petitioner.
Lordship may record my name for respondent number 3, my lord.
So you say Salia for respondent number 3. But then you will be in trouble if finance department has stopped it.
Lordship, because of maybe the budget session going on, maybe some instruction may have been placed. Let me confirm also. In the meantime, I'll confirm with the treasury officer what the petitioner is claiming, if it's actually how.
Because he's saying so, he must.
Like,
be
I'll
doing
just
this.
find out like if there is any shortfall or anything. Maybe they'll release it soon.
Then I add one more line, it will make the things easier. The respondent shall also take note of the fact that till date, there is no order passed by this court to exempt their personal appearance in court. Then they will understand.
Deeply obliged.
39.
Yes, we have the instruction.
May it please your lordship, there is a twofold direction from the honorable court's lordship. One of the direction is that lordship to extend the period of required net slate to 5 years lordship. That part we have done. Even one of the direction was that lordship regarding the basic UGC scale of pay lordship. When petitioner filed the writ petition, it was 21,000 UGC scale of pay lordship. But when we have complied, it is gone to up to 55,000. We have also done that part also. Petitioner paid that lordship, it will be 21,600 lordship. But government has decided it should be lordship 55,000 lordship as a fixed pay.
Close the petition.
Lordship, me peruse the page number 28, Lordship, where the direction is like to pay basic scale pay, including
They have
the.
sanctioned the amount, you are getting more than what you are wanting.
Lordship, as the direction is to pay the basic scale pay, including the area Lordship, as the cabinet order has been passed, where the fixed amount has to be Lordship just 55,000. But in the
No,
basic scale. pay,
you see,
Lordship,
those calculations are not making in a contempt petition. If you have received money, if you have claimed, you
No,
file a
Lordship,
fresh
we have
petition.
not received anything, Lordship.
Okay.
Government has taken decision lordship, first page lordship has seen lordship regarding extension part also there lordship.
Counsel to the petitioner is present. Your name?
M zoom one. I'll write it down. Lordship.
Mr. K. Gogoi, learned counsel for the newly implemented respondent numbers 4 and 5. Has produced a copy of notification dated 4/11/2022. Disclosing that on approval by the cabinet meeting held on 19/10/2022, the Higher Education Department has enhanced the fixed pay of the petitioner to 55,000. And that by another order dated 15/10/2019, in compliance with the order of this court, the Higher Education Department had approved another 3 years beyond 2 years to the petitioner for acquiring net public slate SLET. That's why the General Counsel for the petitioner submits that the petitioner has not got the benefit of enhanced fixed pay. That's what accordingly the matter stands adjourned today to enable the General Counsel for respondent numbers 4 and 5 to inform the court as to whether the orders referred to above has been communicated to the petitioner.
My lord, kept as a part of the record, Lord.
Now this, the instructions produced is kept as a part of the record. Based on 26/4/2023.
Lordship.
You get information because this is something, it is long back. You should have got the benefits. 5 months back, your orders were fast. And one order is about 3 years back into 4 years back in 2019 only. You should have got the benefit by now.
And few of the petitioners lordship, they are already retired and some are going to be retired very
No,
soon.
no, that
lordship.
I'm not concerned with, but it is at 2019.
Yes, lordship.
That has been extended for you by 3 years. That part has also lapsed.
Lordship.
So you must be aware of that. Because otherwise your friends have not informed you.
Oblige, Lordship.
42. 42.
May I please your lordship? This is an application, this is an application for the refund of the amount of 25,000 deposited as statutory deposit, your lordship.
Okay. And Miss
Nazima.
Nazima, now counsel for the petitioner. Next, this interlocutory application has been filed for refund of the sum of this 25,000 deposited under section 173 of the MV Act while preparing an appeal. So it is posited that the connected MAC appeal 517 of 2017 was disposed of by remanding the matter back to the member MACT Nagaon for hearing the claim of MAC case number 128 of 2015 afresh. Accordingly, the registry shall examine the matter and release the statutory deposit to the applicant. Within a period of 2 weeks until the application disposed of.
43.
Much obliged.
Yes, any development?
Your lordship, no, your lordship. We have not been able to trace out that dispatch register because it relates to year 2007.
Because now we'll have to add some more money.
Your lordship,
He is appearing for pro bono now, Mr. Sinha.
I have been instructed by the department that we had actually communicated it to the finance
But
department.
something you have to show because you see, that is the only consideration.
Yes, lordship, at page number 14 is the letter. And I've been told it was issued way back in 2007, immediately 1 month after the rejection of the DLC, which was held on 11/7/2007.
No, you see that statement even you can't. Because somewhere your stand was that the requiring department was to communicate.
Requiring, we have, the prevailing practice is the DLC holds the meeting and communicates it to the department concerned under whom the person was working. The petitioner was working in the treasury office, which comes under the finance and establishment department. Now, in terms of the prevailing practice, we had communicated it to the finance and establishment branch. And in later case also, when it was considered for a second time, when his case, the petitioner's case was considered in the year 2015, then also annex that particular letter also. That is the prevailing practice. We communicate to the finance department and the finance department communicate to the petitioner that he got. But somehow or the other, that the first rejection order was not communicated. Now, our duty in my respectful submission was over when we communicated to the department concerned under whom the petitioner was working. Now, the finance establishment department is saying that we have never received that letter. Now, that is where the difficulty arises. Because in my respectful submission, both the departments are actually government departments, and they are run by responsible government officers. And it's not that this kind of false statements as such can be made, because this letter at page number 14, annexure 1, it contains a specific letter number, everything. In fact, our records also only this letter, the photostat of the letter that which was sent to the finance and establishment branch is there. But original dispatch register which your lordship inquired regarding whether it was, because the mention of that letter number will be there in the dispatch register. But I've been told that since the DC office has shifted from the Kasari office to Angabari, many of those dispatch registers are misplaced and they cannot trace it.
You see, because this is not the solitary case. We have dealt with hundreds of cases where it's a consistent stand of all the most of the aspirants for this compassionate appointment. They are not even aware of their rejection. This is not a solitary case. Day in, day out, we are taking up matters. And then they come up with the stand that 2008 their case was disposed of. Yesterday we got 2000 something 8 or 8. It was disposed of, and the parties are not aware.
That is what you
After that, his case was taken up again in 2015-16. And again disposed. That also he is not aware. When he comes to court in the third round of litigation, now everything comes up that now your cases were disposed of long back.
I understand, but here the prevailing practice is the DLC undertakes the meeting and it was communicated to the department concerned. As your lordship can see from page number 15, annexure 2, when his case was again reconsidered in the year 2015, it was communicated to the Commissioner Secretary Finance and Establishment Branch. This he was aware of. This rejection is aware. So the onus of communicating lies in the department concerned. Here the department concerned is the finance and establishment branch. So they have to communicate to the person concerned.
But their stand is specific, it's not communicated to them.
So let them state it on affidavit, because there lies a dispute.
That can be done. But will that help the case of the review petitioner, my lords? We can put it on record, my lords. That is the stand which from day one.
Just do it, because do it, that's. Well, otherwise, this is Mr. Sinha who is suffering.
Lordship will file it, lordship. Right?
Mr. D. Boral and counsel for the petitioner. Mr. B.P. Sinha, the counsel for respondent number 1. And Mr. A. Shalyal and study counsel for the finance department, appearing for respondent numbers
2, 3, and
2, 3, and 4. Next, the learned counsel for the petitioner has submitted that they are not in a position to trace out the proof of service of order of rejection of claim of the petitioner for, respondent number 1 for compassionate appointment. So it is submitted by referring to Annexure 2 to the rate petition, to this review petition, that the procedure followed by the Deputy Commissioner, Kamloops Metropolitan District, to communicate the DLC DLC resolutions to the concerned departments. And accordingly, it is submitted that the rejection of the claim of petitioner the disposal of the proposals for compassionate appointment was communicated to the finance within bracket establishment dash capital B bracket close department or this full. So it is submitted as that as the treasury is under the control of the said department. Only the said department who can inform the court as to how the disposal of proposals for compassionate appointment was communicated to the petitioner. Next paragraph. The learned counsel for the respondent numbers 2, 3, and 4 has submitted that the stand of the finance department is that the communication was never received by the finance establishment B bracket close department. So be there as it may, it would be appropriate to direct the respondent numbers 2, 3, and 4 to file the affidavit in opposition and take a particular stand in the matter. Accordingly, matters is adjourned today. After vacation, after we will give a date, fixed date.
28/4.
28/4.
28.
Mr. Sinha, we can't take up early. Till view will be engaged.
Obliged.
Lordship, Mr. RTD third is appearing, he is on legs in court number 6. Matter will be fixed for hearing, Lordship.
No, you will not fix it for hearing, you can dispose it off anytime.
Any day, Lordship.
Because if it goes for hearing, it will be delayed. I can't take up later on, it will be adjourned then.
Yes, Lordship. Any day, Lordship.
Give a date after a view edition. Both sides are represented on the pair made by Run Council for the review petition of the matter since it's on today. This on had made 46.
45. In this case, when the government is given time to file affidavit measures.
45.
45.
You want time?
No, the government is given time to file affidavit measure. Earlier date. Not yet filed.
Yes,
Time. Affidavit of
he wants the name of the father to be collected.
Yes, madam.
Yes, Lordship.
What are names of the father?
But Lordship, in the judgment, is Lordship 2011, Lordship. After long,
Maybe
And-
they have realized it now.
But- in this case, Lordship, copy has not been served to me, Lordship, in the last.
Yes, it is out.
Some-
You appeared for respondent for too long back.
Yes.
Yes, Lordship, on the last occasion, Lordship. So education department is Lordship. SMT 60 is there in the last. They had given an objection, Lordship, in education.
You have a copy of the metric certificate?
Yes, madam.
No, you have given a mark sheet. Do you have a
Yes,
copy?
my sheet, madam, yes.
Do you have a copy of your metric certificate?
My lord, I'm sorry, my lord. Yes, my lord. Not with me, my lord. The person is, just a minute, my lord.
Because you must show some admissible proof of that,
Yes,
that your father was someone else.
yes, my lord. That is, metric certificate is not given to me, but let me have one of time.
Okay. Because you have to show a proof of your
Yes, I will do it.
admissible proof.
But in my one application, my lord, your lordship, my lord, that is page 23, in that is my lord, my name was written as, no, 24, my lord. That is, let me produce the.
You see why we are so so disturbed about it. I'll show you this writ petition. Raman, you will also see this.
Yes.
I'll put it in the metric certificate.
No, I'll show you why we need that. This is the rate petition.
Yes.
See that page. Now in this rate petition, you have projected, your father's name is that,
Yes, that's it.
correct?
Correct, Lordship. Now he is.
Now you are coming into court and saying that no, for compassionate amendment, your father's name be changed.
Changed, Lordship.
In it earlier petition that was wrong, my lord.
No. They can't be wrong in two places. You did, you write the cost title differently.
My lord, it is-
Then in
But
the,
in the
in the
document-
application for compassionate appointment, you give your name of your father as same. Two mistakes can't happen.
Father name was same, but it was written as late, my that is there. Actually not that, he was a late. He is a late, killed. That is my lord. Name was there, my median, M-I-R-J-A-N, it should be instead of Z, my lord, it should be Z. That is our spelling.
Okay,
Pronunciation is same, but my lord, spelling is.
spelling is different. Okay.
But I will put the metric certificate, I think.
And-
By affidavit, I will put it, my lord.
Yes, Lordship.
And what about this late and not
But
right?
it is wrongly written, my lord. I admit, my lord, it was wrong, my lord, on my part, my lord. It was.
Your father was
mistake.
alive.
He is alive till today.
Then how compassionate appointment application came when he's
Yes.
alive?
No, he was retirement, service retirement. Father retired from school teacher, my lord. He retired, my lord. Honor return, my lord. He retired from service.
On retirement, you don't get compassionate service. Do you get compassionate service after retirement?
And that is filed much earlier, my lord.
No, not that, but under the scheme,
No, my lord, that today now I do not know it, my lord. That wrong was done on my part, my lord. So I come to you also to correct it, my lord. That is the problem, my lord. What is the behind the what is going on, I do not know. Because it is late, it was order passed on 11.
no, but
2011.
compassionate appointment on retirement, I don't know.
No, that scheme was earlier there. It was abandoned lordship. It was already, it was earlier there lordship.
When
10% is,
10% retired.
that benefit is there.
it was there.
Yeah,
Okay.
earlier, Lordship.
Okay, you get the correct document.
Yes, I will put it.
Whether after 11 years, that correction can be made lordships at this stage.
No, that is a small mistake. I think Mirzan,
And
RJ.
late, but he said
Late.
late was written at the time. He said it was late was.
So those
mistakenly
mistakes is not, so you see, no material. If nobody in good sense will write, you
And-
see, he's claiming.
And whether
upon-
that order after 11 years lordship, even if it is corrected lordships,
No, whether he gets the benefit or not, I don't know, but you
Yes.
see, there are some practical difficulties.
Yes.
A person may, when he's found everything is adverse against, then he finds that his name of the father is, instead of J, it is written Z. Correct, so that is a mistake.
yes,
Late,
late was there. Only because of late lordships,
Ah.
what the person,
but
now he
because,
said late was mistakenly written lordships.
so because if he's claiming on the 10% quota.
Yes.
For
For
retired persons,
That is earlier lordship.
no, that is,
Ah.
he's claiming is under that only.
Yes,
He's claiming as a retired person's beneficiary. So definitely his father will not be late.
it will not be late. Yes,
So those are small things.
Yes, yes.
I'm not
anyway.
much on the small.
Yes. Admit comment, but na.
You see, I'll
Yes.
tell you a story which happened with one of my friends. He was very happy to receive a certificate. Where is in front of his father's name, it was written LT. So he was very ecstatic
Yes.
on the ground that his father was made a lieutenant.
That's-
So he was irritated because of that. And I told him that no, this is LT means late. He says, can't be. Look at the dictionary. Abbreviation of lieutenant is LT. It is not late. Then I saw the dictionary for the first time when I was in college. And then I realized that LT is not late.
Not
LT
late.
is lieutenant.
We used
So,
to
but
write it,
but we got his certificate corrected. At that time, students, we were very jumpy about everything. Immediately those things were done. But that is my education of a lieutenant
Yes.
when I was in college. The boy was right. He showed me the dictionary,
Yes.
lieutenant is LT.
Even today also we write LT Lordship in case of.
No, but that is wrong.
That's wrong.
No, that is wrong. So therefore, at times people don't realize mistakes
Yes,
they are
yes.
making. So every time we can't be so technical. Okay, item 41, 45. Mr. S.K. Noor Mohammed, the counsel for the applicant, is directed to propose admissible proof regarding the name of his father. Gustav. Accordingly, just right, Mr. S.M.T. Chistil, Chronicles for the Elementary Education Department,
Elementary, secondary, elementary.
and Mrs. D.D. Burmat, additional senior government advocate. Preparing for the concerned respondents are present. Next, brother. What's the matter? When, Mr. Noor Mohammed?
My lord.
When?
After 2 weeks, my lord.
Then I fix it after due vacations. We will be busy in that.
Date may be, yes, my lord. Date may be.
Okay. List on 21/4/2023. Yes. Yes.
So there are 3 cases, Lordship. All are serving as lecturers in Dispute College, Lordship. Lordship, they have been serving for 23 years, Lordship. They were duly selected, Lordship, and they were continuing service, Lordship. And being threatened of termination, Lordship, they have approached this honorable court, and the cases are going on, Lordship, from 2014 onwards, Lordship. Lordship, during the pendency of the case, Lordship, on 1/6/2022, Lordship was there, Lordship. On 5/4/22, 5/4/2022. The council who represented the college, Lordship, they said that they were taking up a government body resolution in favor of the petitioners. Lordship has got it, Lordship. 5/4/20.
No, but here is an advertisement which has come out. You want this to be stayed?
Lordship, that has been stayed, Lordship. That has been stayed, Lordship. And Lordship. And Lordship is taking which matter, Lordship? Sorry, Lordship. Sorry, Lordship.
No, the 3 matters. First one takes
matters
before
are
me is the
Lordship.
IA civil. IA civil 1350.
Lordship, right now, I am not pressing the IA, Lordship. I will go to that later, Lordship. But in the meantime, they said that they will take up the regulation of the these teachers, take up the matter with the Director, Higher Education, Lordship. So on that line, Lordship, I stayed away from pressing that application, Lordship.
Yes.
Lordship, I am appearing for the respondent number 3 and 4, principal and governing body of the dispute
Yes.
college, Lordship. We have filed our affidavit on that is on record, Lordship. We have specifically pleaded in our petition, Lordship, in our affidavit, Lordship. We have no objection if the government regularizes their service, because on the part of regularization, the college authority cannot regularize their service. Lordship.
They cannot be regularized because they were it was the internal arrangement of the college, my lord. They were appointed against temporary in a non-sanctioned post, my lord. That cannot be regularized, my lord. It will be illegal. And our affidavit is on record, my lord. We have specifically stated, my lord.
Mr. Bhagwati,
Lordship.
You see, this is something I did not go through it, this repetition. But what I understand from primary preliminary view of it is that you are praying for regularization of your service. Correct. Now you see, unless it can be demonstrated that your appointment was as approved by Umadevi, the question of the court ordering a regularization will not happen.
Lordship, at that time, what prevailed, Lordship, that they were temporarily appointing people, Lordship, and in the long run, Lordship, when they had sufficiently number of years in service, Lordship, they were called for, Lordship. In Dispur College also that happened, Lordship, in 2004, 2005, Lordship. They used to regularize people, but these people, these three petitioners were never taken up for consideration.
No, you see, that
Honorable courts-
regularization, that's what I am asking you.
Lordship.
You see, post Umadevi, this is something which the court cannot order. That has
Lordship.
been barred.
Because there are certain orders of this,
The Supreme Court's language is very harsh.
Lordship, that is there, Lordship. Supreme Court directions are also there, Lordship. If they have served for 10 or more years, Lordship. That is
Only
also
one
there,
time
Lordship.
measure, but this one time measure will not apply here because this is post Umadevi. But this is not a recurring.
These are prior to their, Lordship. They are serving for 22 years, Lordship. Till now, more or less 22 years they have.
You see, post Umadevi, there was a requirement of doing one-time exercise. But
Lordship.
that has lapsed.
Lordship.
That Umadevi is 2006.
Lordship.
After the lapse, now in 2023, we
Lordship.
can't order a one-time exercise because ML Kesri and others, they have clarified that it can't be a repetitive exercise. One-time exercise means one-time exercise. That has been clarified in subsequent judgments.
Lordship. At least they should have been taken up for consideration their cases, Lordship. They were never taken up for consideration. They didn't even write to the Director of Higher Education or the government that these people are serving in our college, what to do with them.
No, that
That
is what
exercise they should have done, Lordship.
No, you show that that exercise is that exercise is a mandatory requirement.
Lordship, last order, Lordship, may see that point was raised on the last occasion,
No,
also, Lordship.
You see, that is okay. We record whatever you are submitting.
Lordship,
But when it comes to final adjudication,
Lordship,
then there are different parameters to look into the matter.
Lordship,
For interrogative purposes, whatever we write is one part.
Lordship.
The second part is that you have to now demonstrate your right to have your candidature considered.
Lordship, one thing is that, Lordship, another thing is natural justice, Lordship. After 22 years, Lordship, where will they go, Lordship? That is another thing, Lordship.
But
After
that has already
22
been
years
answered in the
service in the
Umadevi.
college, Lordship, that too for a mere salary of 7,500, Lordship. They have been paying that much. For 22 years, Lordship, you cannot imagine, Lordship. They are, everyone have crossed 50 years, Lordship.
But it can't be helped. There is a situation, it's a human problem, but we can't have answers to that.
At least they should have taken up the issue with the higher education, say what we are going to do. Why do not the college write to the higher education? Let the higher education clarify, Lordship.
No, you see that you can do without the court order, but the court will not pass an order to the director to dispose of the representation because that is something which can't be done. You see, I must first adjudicate and find out that there is some right which is accrued to you, and then ask the authorities to dispose of the representation. But I can't just direct every representation to be disposed of. Tomorrow somebody comes and says that no, the government is distributing scooty to girl students. I am a boy student. I have submitted a representation. I also need a scooter. That representation can be disposed of, can be sent to the government for disposal.
That is why, Lordship, by the earlier direction, Lordship, the college was asked to take up the issue with the higher education, Lordship.
No, but it is legally permissible. That's what I am saying. You see, for interim purposes, we pass so many orders.
If we take up the question of natural justice also, Lordship, will it be good to throw them out from the college, Lordship, at this period of time,
No,
Lordship?
that may not be done, but you can still,
Some
you
sort
see,
of arrangement they can
for
make,
22
Lordship.
years
They
you have
have never
continued.
tried, Lordship.
For 22 years, you have continued, but notwithstanding that, whether you or Mr. Chaudhary agree to it, but regulations, it can't be ordered.
some ways should be found out, Lordship, so that they cannot be deprived, Lordship, after such a long period of time in service, Lordship.
My lord, if I correct,
No, way is there, but you will not take it. Way is only to get yourself elected in the assembly and then have the law altered. Well, you see, legally speaking, we don't have an answer to by the court can't do anything.
Also, time and again, they have been requesting the court that you give us some time. We will discuss the matter in the governing body meeting and we'll take up the issue.
No, you see, that's what I'm saying.
Well,
Even if we
in that
agree.
case, Lordship, if they take up the matter themselves, Lordship, the honorable court may not interfere in those things, Lordship. Lordship, when they themselves take up
No,
the
they have,
issue, Lordship.
Mr. Chaudhary is saying that they have already taken up a decision.
No, Lordship, no decision has been taken, Lordship.
He said there is no objection.
In our affidavit, Lordship, we have clearly stated, Lordship, may I read, Lordship? Page of 13, I am reading, Lordship, so and so, so and so. The matter
But
of
still, that is something else. But the question is that even that concession
Lordship.
won't entitle to the order of the court for regularization. This is something which can't be ordered.
Lordship, long pendency in service, Lordship, there are certain orders of this, of the honorable court also, Lordship, apex court, Lordship.
Show me one.
Lordship.
I think for other matters, I would not have time to take up.
Item 50, maybe it's the day after tomorrow, there is some website. I am my lord.
What is the IFO?
It is my lord, petitioner is from LIC. Joint loan applied with the husband. Her, my lord, no objection has been withheld on a peculiar ground, my lord. Last occasion it came before learned single judge, my lord, he observed that this is not the way. Anyway, he directed the two circulars to be put on record, which I put on record. Day after tomorrow.
Okay.
50, much right.
You see, post Uma Devi, this will not have a what you call a persuasive force. 1991 Supreme Court and in 1992 AIR.
Lordship.
All these are prospectively overruled by Uma Devi.
Also, because there were, while they were in service, Lordship, there were vacancies also, Lordship.
No, but it can't be undone. Today, I can't undo it and say that you will be appointed under the old vacancy.
Let the college themselves try something, Lordship. Instead of, Lordship, throwing them out, Lordship. Let them find a way, Lordship.
But not from the order of the court, they can do it by themselves.
Lordship.
Because you see, the only relief we can grant you is to the extent of the directions contained in Upen Das. But Upen Das again is applicable only for the work charge employees.
Lordship.
The benefit of scale pay for a professor, the rank of a college teacher, I don't know whether it is covered or not. Yes, what do you say about Upen Das?
Yes. my lord. I think my lord, it will not cover in case of teacher, my lord, assistant teacher or apprentice is. মাস্টার রোল ওয়ার্কার সেগুলো করে দিয়েছিল। ইমান বছর পড়ার কারণে চলতে হবে।
This will not help you. Upen Das also doesn't help you.
Lordship.
Because that was only for the work charge employees. And decision was taken by the cabinet to give that benefit.
Lordship. And moreover, Lordship, these colleges have their own sets of rules, Lordship. They, what I said, Lordship, in a different period of time, they just pick up the people who were in service, Lordship. There's that Lordship, in that manner, Lordship, many people were regularized, Lordship. But because here, the earlier principal, he was not in favor of these three petitioners, Lordship. So their cases were never sent to the higher education, Lordship. Even the governing body did, Lordship. Governing body wrote to the higher education, Lordship. But the principal was against it. Now the present principal says that give us some time, we will place it in the next ZB. But that is not happening, Lordship. ZB is not sitting, Lordship. Maybe Lordship, give some time, Lordship. They may take up the matter with themselves, Lordship. That ZB can take up the matter, Lordship, with the government. Let the government say, Lordship.
Okay. The closing repetition will give you a liberty to the government to move the government.
Lordship, if it is closed, Lordship, then they will not do anything, Lordship. For the timing, Lordship.
So
Let it
then we
come after
only
the-
adjourn the matter
let
in
it-
your prayer. We don't
Lordship.
say anything.
Lordship.
On the all sides the duty represented on the prayer made by Mr. A. Bhagawati and counsel for the petitioner. Matter is adjourned today. List after ensuing new vacations.
Lordship. That's okay.
Because in this Uma Devi, what is very categorically stated. You know that
Lordship.
The power of the court.
Lordship, I know, I know the limited power, Lordship. I understand, Lordship. That is why I am pressing with the college, Lordship. And if the college shows some favor, Lordship, it's up to them, Lordship. And because the principal was bad against these people, Lordship, against these three persons, Lordship, ladies.
No, I can tell you the government is not going to do it because of the fact that it is not only a solitary case. We have so many cases coming in
Lordship,
Delhi.
It
In all
may
the-
be a solitary case,
all the-
Lordship.
all the schools
Because
and colleges.
22 years service, Lordship. I think there is no college left in Assam, Lordship. With 22 years of service, Lordship. College ceases left.
Only college can assure, my lord, that not to terminate them up to 60 years or